Please come to order for the November 15th regular meeting of the Ascension Parish Council. Please stand for the prayer, and the pledge tonight will be led by Eagle Scout Joseph Lambert. The prayer tonight be by Councilman Randy Cluott.
In the name of the Father, Son, Holy Spirit. Dear Lord, we thank you for this day. Lord, we sincerely appreciate you carrying our Gulf South region, South Louisiana, and Ascension Parish especially, through the hurricane season unscathed. Lord, we turn toward the cold weather, and we look at those that have less than us, and those that cannot do for themselves. We ask that you look around and take care of them, and let's look to our neighbors left and right. We ask this in the name of your Son, Jesus Christ. Amen.
Amen.
Please join me in a pledge of allegiance. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
If you'd have said it out. We got a full council tonight. Okay, roll call, Madam Secretary. All council members are here tonight. There are no chair additions. Public comment sign-in period. If you'd like to comment on an agenda item, please pick up a card at the podium and bring it to Parish Secretary. You'll be allowed 3 minutes. Presentations tonight. Mr. Matassa.
Mr. Joseph Lambert, come up, please. On October 4th, 2018, Joseph Lambert, the son of Kevin and Michelle Lambert, achieved the rank of Eagle Scout. He is a member of Troop 65 in Gonzales. Joseph is 15 years old and attends Santa Maria High School, where he is an honor student and a member of the ROTC drill team. Joseph earned 36 merit badges. 36 merit badges.
Wow.
Wow.
Yeah, that's impressive.
On his journey to Eagle Scout. Joseph's Eagle Scout project included identifying and locating grave sites of the veterans buried in Cornerview Cemetery, which I did not know.
Wow.
He identified 88 veterans' graves representing all branches of the military, including 26 Civil War veterans. Joseph installed a concrete bench and marker to honor all vets buried in the cemetery. So tonight we're here to recognize Mr. Joseph Lambert, Eagle Scout. Want to come up and take a picture? Go ahead, John. Come up and take a picture.
Come on, let's invite the family to come and join us. I'm gonna let Sure. Okay. I cannot see these two council members.
Perfect.
Yeah, that may be a good thing, yeah. Yes. Gonna take a couple. Not get a merit badge in photography. Wait, let's do one more here. One more here. Other camera.
Contact you tomorrow and you help me identify all the people in the photograph.
Yes.
Okay.
Okay, item number 6, the parish president's report. Mr. Matassa.
I don't have anything tonight, Council. Thank you.
Item number 7, consent agenda. Ms. McKee.
Roads for acceptance into the parish maintenance system, Keystone of Galvez, PUD, 4th and 5th filings, Marblestone Avenue, 2,166 feet. Amendment number 6 to master contract for general engineering consultant services, transportation master plan development and implementation between HNTB and Ascension Parish government to review the existing contract for an additional year with a budgeted amount of $1.2 million for the term of this contract. Approval of resolution and capital improvements plan as required by the Parish Transportation Fund Act. Approval of substantial completion for Gravity Line, Highway 42 and John Broussard Road. Contract renewal for GSA for utilities, general engineering, and technical support not to exceed $150,000. Approval of agreement with Broad Blast Everbridge for software for the AP Citizens Service Center, $34,742.28. Amendment number 3 to the master contract for professional services with Mujo Architecture, LLC for additional architectural and engineering fees for Geismar Main Station number 80, additional $36,772.60. Amendment number 3 to master contract for professional services with Mujo Architecture, LLC for additional architectural and engineering fees for Sorrento Main Station number 20, additional amount of $24,483.51. Amendment number 5 to master contract for professional services with Mujo Architecture, LLC for additional architectural and engineering fees for the Santa Maria Fire Station number 60 due to revised construction cost estimate for an additional amount of $36,044.59. Bid items to accept lowest responsive bid as follows: limestone number 57, gray and Mexican, number 89, gray, and number 610, gray and Mexican, Renee's Trucking. Engineered wood fiber, Phillips Bark Processing Company. Premium red shredded hardwood mulch, Irrigation Mart. 6-yard dump truck, 2 units, Timmons Truck Center, $175,284. Polyvinyl chloride, PVC, sewer drainage pipe, Kedco. Bridge material and round timber piles, MCM Lumber Company. Shavings, screen cottonwood or white pine, S&S forms, $4.50 per bale or bag. Pumped sand and river silt, Renee's Trucking. Approval of request for quote, Janelle Street Driveway, L&O Construction Company, $28,731. Approval to amend the Ascension Parish Unified Land Development Code Appendix 5 Drainage Section 17-5013 Design Criteria, increasing detention pond capacity from 10 to 25 years.
Motion, Mr. Chairman. Is there any desire to move any item? Mr. Satterley.
7A, I object.
Okay, so we will remove item 7A and move that down to after the consent agenda. Any desire to move any other items? We still have a motion by Councilman Todd Lambert to adopt the agenda, the consent agenda, second by Councilman John Cagnolati. Any discussion? Any opposition? Motion's adopted. Now we go to item 7A.
Move to accept.
Got a motion by Councilman Dempsey Lambert,
Second.
second by Councilman Randy Cluott to accept item 7A, which is roads for acceptance into the parish maintenance, Keystone of Galvez, PUD, 4th and 5th filing, Marblestone Avenue, 2,166 feet. We have a motion and a second to accept that. Any discussion? Any opposition? Opposition. Have one in opposition, Madam Secretary. Open the voting machines. Please cast your ballots. Please close the voting machines. The motion is adopted 10-1. Okay, committee recommendations, item number 8, approval to amend the Unified Land Development Code Appendix 1.5, Subdivision Regulations, Section 17-405.e, adding language to not allow preliminary plat approvals with contingencies. Recommendation from Strategic Planning. We have speakers on this item tonight. And the first speaker that we have is Sharon Sanders. Come up, please. You have 3 minutes.
Good evening, Council. I support adding language to not allow preliminary plat approvals with contingencies. I believe in voting for the common good, so I support adding this language to not allow preliminary plat approval. Thank you.
Thank you. Next speaker, Mr. Joel Robert.
Good evening, gentlemen. I've heard some different people talking that we are looking to change it from the initial or the first plat to no contingencies on the final plat. I think that sounds fair. As long as, and I think a point needs to be made here, there are no contingencies that permit the selling of any homes before the final plat is approved. Also, any and all contingencies must be met before final approval, because once the final plat is approved, we all know there's nothing that we can do to hold them accountable to finish what they said they were going to do, or whatever the contingencies told them to do. So if a developer comes to the Planning Commission for final plat approval without doing those contingencies to which he agreed to beforehand, I mean, there's no other option than denial. And with that said, I feel like no contingencies in the final plat approval, with that one point being made about not letting them sell homes before the final plat. Thank you.
Okay. Ms. Catherine Goppel.
Good evening, council members. I supported this as it came out of strategic planning. Obviously, there's going to be some changes in your in the proposal. Noah Webster's definition of a contingency is an event that may but is not certain to occur. Condition is a synonym of contingency. Section 17405E of the Ascension Unified Development Land Code states the Planning Commission shall, at its regular meetings, discuss the plat as to conformity with subdivision regulations. The Planning and Zoning Commission shall express its approval or disapproval and reason therefor. Contingencies are not mentioned. Currently, the Planning Commission routinely approves preliminary plats with contingencies. The fact that additional conditions or contingencies are being given to approve such proposed development says that these plans do not meet our current code. Contingencies provide a loophole for the developer to skirt around our laws, trample on the rights of adjacent property owners, and continue to overload existing infrastructure. These plats should not be brought before the Commission for approval until all conditions are met. Members of this council have decided to allow contingencies when preliminary plats are approved, but not to allow contingencies on the approval of final plats. We will get nothing different than what we have already. Outcomes do not change. This is business as usual. This is not a compromise, it's a ruse. You may have fooled yourselves, but you have not fooled the people. What you are doing here is counting 6 votes. You are not doing what is right for the people or for the future of the parish. Allowing contingencies on preliminary plats will not ensure that infrastructure deficiencies in the design of future development will be addressed. Why do we have this overwhelming deficit? Council members have appointed commissioners who have consistently shown disregard for the principles of the master plan. They work for developers and they turn a deaf ear to the people. Most council members have turned a blind eye to many of the egregious actions of this commission. And contingencies are given to approve development, but loopholes are actually created to our laws to increase our infrastructure deficit. The problem is not what laws we have on the books. Changing the code will not change reality. This current planning commission will not enforce the law, and the parish council will not hold them accountable. We do not need better laws. We need better men and women to enforce and follow them. What we need are council members who will truly desire to work for the betterment of the parish and its people, members who will appoint planning commissioners who will follow the law. Thank God, next year is an election year. Thank you.
Okay, Ms. Kimberly Christie.
Hi, my name is Kim Christie, and I live in Prairieville. And I think it's important that while we consider policy regarding the Planning Commission, we keep in mind that CPEX, in preparing our master plan, has researched, analyzed, and documented that the people of Ascension want infrastructure in place prior to development. I think this is a step in the right direction. There's still a lot of work to be done, and I appreciate all of your efforts in realizing that goal. Thank you.
Thank you. We have 2 additional cards that people were turned in green cards and chose not to speak, Ms. Teresa Robert and Ellie M. Brooks. All right, gentlemen, item number 8, approval to amend Unified Land Development Code, Appendix 1-5, Subdivision Regulations, Section 17-405E, adding language to not allow preliminary plat approvals with contingencies.
Mr. Chairman.
Mr. Sadley.
Thank you, and thank all the public speakers tonight. Albeit this was a unanimous recommendation coming out of the Strategic Planning Commission. As you know, Mr. Chairman, since you sit on the same, the intention of what we wanted to do is not necessarily right now reflected in, and I would ask the public to consider this, in the changes to be made part of our packets this afternoon. As you've just read aloud, it deals with both what I believe is going to work out to be an inappropriate section of the code, as well as where we want to apply this new language of approval with contingencies and or conditions not being allowed. And that is the situation that some of the speakers had mentioned. Well, I guess word gets around. Preliminary plats versus final plats. So I'm going to make a motion, and I might add, I've talked to all other strategic planning committee members who have voted with the language, with the preliminary plat wording, to make it at the final plat, to change that word to final plat, as well as to have, and I spoke to legal about this just in antechambers moments ago. I'm not sure where the code is for the final plat, but he said he would identify that and move the language to the appropriate spot. So we'd fix both of those issues, preliminary to final plat, as well as section with the one motion that I'm going to make. So the motion is to approve. The language will be an addition to our Unified Land Development Code in the appropriate spot, that approval of a, not preliminary, final plat with contingencies and or conditions is not allowed. And that's
So we
it.
have an amendment offered by Mr.
I'll second
Sadley.
that.
Got a second by Mr. Lawler. Any discussion? Mr. Kluart.
Yes, and Mr. Sadley, Doc, you might could, since it came out of your committee, and I wasn't there that night. I don't serve on it, but I wasn't. Has the planning and zoning department, everyone? I would like to hear from Jerome. Is there any reflection on the family petitions on this?
I couldn't
I
hear
want that clarification.
Yeah, I'd like to express a few words about this and let you know that I guess I'm using the words contingency and condition synonymously. I think that you mean the same thing by those. Correct me if I'm wrong. But conditions placed on preliminary plat, preliminary approvals are commonplace across the United States in the planning profession, along with planning commissions and councils, whoever put these. And I'll give you 3 examples right now of conditions that were placed on preliminary plats within Ascension Parish within the last 5 or so years. Number 1 is the Belle Savon project in Terry Castle, in Councilwoman Castle's district, where a condition was placed on that project where the 3rd phase of that project cannot move forward until Belle Savon Avenue is connected to Bluff Road, right? That was a condition that was placed on that project, and it was to the benefit of the traffic concerns within that area. The second project was Pelican Crossing, which is in Councilman Dawson's district, and that project had a condition placed on it that said that you're going to pay traffic impact fees to the tune of X number of dollars, and this was before our traffic impact fee program was put together. That was a condition on that plat at the preliminary stage, and those fees were paid prior to us having a traffic impact fee program in place. The third one I'll bring to you is the Riverton project on Highway 22, and I think that's between Councilmember Dawson's district and Councilmember Travis Turner's district. And that project has a condition on it that they will construct a traffic circle at the entrance of that project before subsequent phases of the project can be built. All of these are to assist in the traffic flow of the parish. So conditions are very commonplace and placed on projects throughout the country. Lastly, I'd like to bring up the fact that we just adopted the new traffic study policy, and the traffic study policy basically allows us to put conditions as mitigation measures for projects that are coming forward before the parish. So these are things that will help alleviate some of the traffic concerns based on our new traffic policy that would allow us to say that you're going to have to build a turn lane, you're going to have to participate in the construction of a traffic circle. These are conditions that are placed on the preliminary plat level that I think is a benefit to the parish, not a detriment to the parish. Right? So.
Mr. Cluott.
Yeah, and I guess back to my original, thank you for that. And I want to speak a little bit more on that, but back to I think Doc may want to answer is if they gave any reflection on the family petitions as, minor subdivisions on this rule. But just back to what you were talking about, conditions versus contingencies.
Right. Well, I've looked at them as the same thing. I think what you're describing as a contingency is also a condition. I'm not quite sure. I'd never heard that term before used as a condition, but I'll
you may have a condition that is written into the contract per
Correct.
se that has to happen, and it may happen at a later date.
That's correct. That's correct.
And
As the
that's
three examples I gave.
Yes.
Right.
Okay.
Exactly.
So vote for this tonight would mean that there would be no conditions.
Well, as I understand it,
you couldn't make
it's
any
been-
future changes based on
Right.
expansion of a subdivision or whatever.
Now, as I understand Councilmember Satterlee's motion to modify this at the final plat stage,
The final,
is that the final plat, before the final plat can be approved, all the conditions that have been placed at the preliminary plat level have to be met. And I would totally agree with that. you know.
okay. Well, I just,
Yeah.
Doc, I'm gonna go ahead and yield to you. Maybe you can explain that to
Yeah.
me. I'm just wondering how
Be glad to,
something
Randy.
in the third filing, Doc, is gonna be met.
Yeah,
before
I
it
think
gets there.
I think we're actually all on the same page, and I'm not sure if Jerome actually caught your real question about family petitions, so I'll start with that, and then segue into not a counter argument on preliminaries, but why we definitely need it, at least at the final stages. The intention of the committee in discussions was never to affect family petitions, so put that in the record. That said, I guess I wouldn't call it a knee-jerk. We had extensive discussion. We were dealing with this from an angle that, Jerome put up 3 examples. I could put up dozens. We've had contingencies on preliminary plats where, $100,000 to be placed in an escrow account by the developer to remove a weir that would require the East Ascension Drainage Commission to make a decision on, and it never goes in front of them. We've had others where at 9:30, where we're going to put a lot of asphalt to widen a road that disobeyed the Unified Land Development Code in terms of its width being less than 18 feet as a contingency/contingent. And I'm glad we all can agree now that those are synonyms. We've had roundabouts. A good example, just last night, a developer came forward, although they withdrew their application, D.R. Horton Homes, to ask for a variance, Mr. Kluot, of a variance, which I think is just even gone even further. So, you know, and in that particular case, let me add, the preliminary plat was done back in 2015, and it had two contingencies on it that I can read and have read on that plat. But somehow, I'm just going to say mysteriously, they both disappeared when the final plat came forward in 2018. And so I've always said, and I've said this as a planning and zoning commissioner for just 1 year before I began serving as the District 4 councilman, and having again gone through Capital Regional Planning Commission training, where I was taught that while what Jerome said, it may be true that this is happening nationally. I wouldn't debate that on a preliminary plat situation. Certainly, it should not be allowed thereafter. Otherwise, as Ms. Guppold said, and I agree, you're providing a tremendous loophole for developers. In other words, presently, we have, Mr. Kluot and my colleagues, no contingency/condition police in our Unified Land Development Code. So what we're seeking to do here tonight is by taking this language, which expressly states that we will no longer allow approvals, changing the word preliminary, of final plats with contingencies and or conditions to the proper spot, trusting Mr. Parrington to do that. And he indicated in any chambers moments ago, he's obviously fully capable and willing. That's why I made the motion the way I did.
Okay. If I could extend that a little further to the final plat approval process. When final plats come up for approval, we have a checklist. And in that checklist, we go through all the conditions that have been placed in the plat during the preliminary approval process. They have to meet those requirements.
Right, and I would suggest,
and if they don't,
I wouldn't tell you how to do your business, but I would suggest that if you have a preliminary plat and it's got two conditions on it in 2015, I would build off of that plat so those conditions remain, so that the Planning Commission can see, yes, they were met or not. We should not allow, I mean, I looked back at the tape of the meeting, and we have, admittedly by his own admission, a chairman of that appointed board by this council, our Planning Commission, I will give a name, that's Mr. Matthew Pryor, saying that, okay, enough is enough. Well, I'm sort of bent to pro-development. He said, you know, I just can't approve this because we said it was contingent upon this, and we have to have those things there. And they weren't on that final plat. So, again, Jerome, I know y'all doing a good job. You're probably like all of us, overworked and underpaid and so forth. I just want to be absolutely certain that going forward, these developers understand that when you spend the money and you come forward for the final time and you want to start selling lots now, that you are going to abide by the decisions previously made by our legislative body legally appointed by this council, the Planning Commission, in terms of contingencies and conditions.
Okay. I'll be prepared to expand. I know we have an agenda tonight when this comes up before you again.
Yeah. So this is the first step in the process. This is just to prepare the ordinance, and we still have to have introduction, and then we have to have final passage of the ordinance. So we have a motion and a second. Any further discussion? Any opposition? Hearing none, that motion is adopted. Item number 9, general business, approval of site sponsorship between the Parish of Ascension, Lamar-Dixon Expo Center, and Mockler Beverage for a period of 1 year beginning on December 1, 2018. Kyle, what it look like jazz?
It's jazz. Kyle's not here. So what this is a signing sponsorship between Lamar-Dixon and Mockler Beverage, kind of similar to our Coca-Cola sponsorship. It's above our threshold that we have, so we wanted to present it to you guys today.
Motion.
Second.
Got a motion by Councilman Kluot, second by Councilman Lawler. Any questions, any discussion? Any opposition? Hearing none, motion's adopted. Thank you, Jan. Item number 10, approval of request for quote for Hidden Farms Pump Station Controls. Ms. Shivers.
On October 17, 2018, the Purchasing Department received 4 quotes for the Hidden Farms Pump Station. After review, the Purchasing Department and Public Utilities recommend accepting the lowest responsive quote submitted by wastewater treatment and to authorize the parish president to enter into any applicable agreement or contract for this project.
Got a motion by Councilman Dempsey Lambert. Second by Councilman Cagnolati. Any discussion? Any opposition? Motion is adopted. Thank you, Ms. Shivers. Item number 11, authorization of matching funds of $335,001 to the U.S. Corps of Engineers for the Hillryville Sewer Project. Mr. William Daniel. What's the dollar for here? That's what I'm wondering.
Somebody, typo.
You mean the penny?
Typo.
That's a dollar, $335,001.
Oh, okay, it is $1.
Yeah.
Mr. Daniel.
Thank you. Honorable council members, this is an item where we have received $1 million from the Corps of Engineers for the Hillryville Sewer Project. Hopefully, in the next utility meeting, I'll be bringing you a proposal to build a pipeline to connect to this plant. This is the matching funds from the Corps of Engineer program.
So moved.
Second.
Got a motion by Councilman Aaron Lawler, second, who was Councilman Benny Johnson. Mr. Daniel, can you tell me the matching amount?
Let's see.
I'm sorry?
What, the amount the Corps is going to put up?
$1 million.
Okay, 335 for $1 million.
That's it.
Most people would take that trade. Any further discussion? Any opposition? Motion's adopted. Public hearings. Item number 12, reading of ordinance to amend the 2018 budget and appropriate the 2019 budget for Parish of Ascension. Mr. Parrington, are you going to? Yep.
Yes. Ms. Dawn and Ms. Gwen asked me to read the amendments because I think there have been some amendments made.
Okay.
And so I'm going to read those and then I'll read the amended budget. Okay, additional amendments for the 2018 amended budget, operating budget, road and bridge fund, revenues and other financing sources transfer in from sales tax district number 1 increased by $150,000 for additional construction costs associated with the DPW fueling station project. Expenditures and other financing uses. Transfer out of building construction fund, Public Works Building East, an increase by $150,000 for additional construction costs associated with DPW fueling station project. East Ascension Drainage Fund, expenditures and other financing uses transfer out to Office Building Construction Fund, Building Public Works Building, increased by $150,000 for additional construction costs associated with the DPW fueling station project. Sales tax district number 1, expenditures and other financing uses transfer out to Road and Bridge, increased by $150,000 for costs associated with DPW fueling station project. Health Unit Fund, expenditures and other financing uses transfer out of Health Unit Construction Fund, increased by $200,000 for Senior Citizen Wellness Center. Lighting District number 1, revenues and ad valorem and other sources. Ad valorem taxes decreased by $3,500 as per millage. Final 2018 millage report from Ascension Parish Assessors Office. Enterprise Internal Service Funds, ACUD number 1, revenues and other financing sources. User fees, ACUD number 1, increased by $25,000 for sewer fees that were not originally budgeted. Additional amendments to 2018 budget continued. Capital projects budget, revenues and other financing sources transfer in from road and bridge fund, increased $150,000. Additional construction costs associated with DPW fueling station project. Transfer in from East Ascension Drainage Fund, increase $150,000 for additional construction costs associated with DPW fueling station project. Expenditures and other financing services, architectural and landscape services increased by $30,000 for expense incurred in 2018 instead of 2019 as originally budgeted for the DPW fueling station project. Professional services increased by $10,000 for expenses incurred in 2018 instead of 2019 as originally budgeted for the DPW fueling station project. Health Unit Construction Fund, revenues and other financing sources transfer in from the Health Unit Fund, increase of $200,000 for Senior Citizens Wellness Center. Waste and Wastewater Construction Fund, expenditures and other financing uses, appropriations and gains increased by $335,000 for matching funds to the U.S. Army Corps of Engineers for the Hillryville Sewer Project. Additional amendments for the 2019 budget, operating fund, Special revenue funds, road and bridge fund, revenues and other financing sources transfer in from sales tax district number 1, increased by $250,000 to purchase a pothole patching machine to be used with hot mix asphalt. Expenditures and other financing uses, acquisition equipment increased by $250,000 to purchase a pothole patching truck to be used with hot mix asphalt. Sales and use tax district number 1, revenues and other financing sources transfer in loan payment from recreation fund increased by $348,000 for annual debt service payment. Expenditures and other financing uses transfer out of road and bridge fund increased by $250,000 to purchase a pothole patching truck to be used with hot mix asphalt. Transfer out loan to park construction fund increased by $3 million for potential recreation projects. Loan in the amount of $3 million to be repaid over 10 years at 3% interest. Recreation fund expenditures and other financing uses, site work at parks decreased by $348,000 in order to fund the annual debt service payment due to sales tax district number 1. Transfer out repayment of loan to sales and use tax district increased by $348,000 for annual debt service payment. Lighting district number 1, revenues and other financing sources, ad valorem taxes decreased by $3,500 as per the 2018 final millage report for the Ascension Parish Sheriff's Office. Enterprise internal service funds, ACUD number 1, user fees, sewer ACUD number 1 increased by $50,000 for sewer fees that were not originally budgeted. Additional amendments to the 2019 capital budget, capital projects. Office Building Construction Fund, Public Works Building East, expenditures and other financing uses, engineering decreased by $40,000 for expense incurred in 2018 instead of 2019 as originally budgeted. This is for the DPW fueling station project. Contract payments increased by $300,000 for additional construction costs associated with DPW fueling station. Health Unit Construction Fund, revenues and other financing sources, intergovernmental miscellaneous revenues increased by $200,000 for revenues from the Ascension Parish Council on Aging for Senior Citizen Wellness Center. Expenditures and other financing uses, contract payments increased by $400,000 for additional construction costs associated with the Senior Citizen Wellness Center. Park Construction Fund, revenues and other financing sources transfer and loan from sales tax district number 1 increased by $3 million for potential recreation projects.
Motion. Got a motion by
Now I
Councilman.
got to read, that's the amendments. Now I got to read the budget.
Oh, keep going then.
Read the ordinance.
Okay.
Took a break.
All right. Let me catch my breath.
Yeah.
Hold it.
All right.
Hold on to that motion.
Yeah, hold it.
Ordinance for amending 2018 budget and appropriating 2019 budget. Whereas a revision of certain budgets for the 2018 budget year for certain funds has been prepared and submitted to the council as follows. 2018 general operating surplus deficit negative 2,535,800 with a fund balance of $11,659,523. Road and bridge negative 369,500, fund balance $61,650. East Ascension major drainage negative 26,562,500 with a fund balance of $22,958,666. West Ascension drainage negative $738,500 with a fund balance of $892,759. Sales and use tax surplus of $936,000 with a fund balance of $18,753,019. Criminal court fund negative $24,000 with a fund balance of $19,041. Health units negative $1,007,000 with a surplus of $481,481. Health unit surplus of $738,000 with a fund balance of $7,296,843. Fire District Number 2 surplus $16,500 with a fund balance of $1,491,726. Recreation negative $989 with a fund balance of $4,086,210. Lighting District Number 1 surplus of $17,500 with a fund balance of $418,007. Lighting District Number 2 surplus of $44,000 with a fund balance of $278,550. Lighting District Number 3 surplus of $18,500 with a fund balance of $238,385. Lighting District Number 4, surplus of $14,000 with a fund balance of $160,680. Lighting District Number 5, surplus of $8,000 with a $146,143 fund balance. Lighting District Number 6, surplus of $153,500 with a fund balance of $2,447,143. Lighting District Number 7, surplus $5,000 with a fund balance of $74,021. Library Bond Fund, a negative $2,500 with a surplus of $394,108. LCDBG Lemonville Sewer Project, no operating surplus and a fund balance of $89,893. Lamar Dixon Expo Centers, negative $530,000 with a fund balance of $1,214,268. The Jail Construction Fund, surplus of $710,000 with a fund balance of $760,000. SNU Tax Sinking Fund, surplus of $102,000 with a fund balance of $1,020,746. East Ascension Major Drainage Sinking Fund, surplus of $71,500 with a fund balance of $656,646. East Ascension Construction Fund, surplus of $26,443,000 with a fund balance of $44,974,392. Courthouse Construction Fund, negative $975,000 with a fund balance of $24,205,82. Road Project Construction Fund, surplus of $1,230,000 with a fund balance of $13,736.78. Equipment installed, purchase, debt service, zero, fund balance of $13. Ascension Jail Fund, deficit of $54,000 with a fund balance of $179,445. Law Officers Court Fund, surplus of $25,500 with a fund balance of $75,049. Office Building Construction Fund, $638,000 surplus with a fund balance of $1,553,558. Ascension Insurance Fund, surplus of $502,000 with a fund balance of $3,446,444. HUD Section 8, zero surplus, zero fund balance. Parish Court, deficit of $236,500 with a fund balance of $541,273. Move Ascension Construction Fund, deficit of $10,231,500 with a fund balance of $26,686,330.
$6 million.
I'm sorry?
26
Oh,
million.
well, 26 million, I'm sorry.
Oh, that's a lot of money.
Health Unit Construction Fund, $625,000 surplus with a fund balance of $625,000. Fire District number 1, operating deficit of $3,570,500 with a surplus of $3,660,099. Council on Aging, surplus $69,300 with a fund balance of $1,847,704. Sales Tax District Number 2, Sales and Use Tax District Number 2 Fund, surplus of $3,500 with a fund balance of $131,034. Sales Tax District Number 2 Sinking Fund, a surplus of $7,500 with a fund balance of $908,566. 23rd Judicial District Fins Fund, deficit of $15,500 with a fund balance of $27,704. Fire District Number 2 Construction Fund, deficit $14,500 with a fund balance of $267,500. Fire District Number 1 Construction Fund, $1,511,500 with a fund balance of $5,092,637. West Ascension Drainage Sinking Fund, zero, and a fund balance of $61,434. West Water Wastewater Fund, deficit of $501,000 with a fund balance of $10,030,540. Dedicated Special Fund Project, 0 funds, and 0 fund balance. Ascension Parish Maintenance Fund, deficit of $518,000 with a fund balance of $1,258,152. Dental Insurance Fund, surplus of $11,000 with a fund balance of $98,303. FEMA Repetitive Loss Acquisition Elevation Funds, a surplus of $116,500 with a fund balance of $1,353,039. Infrastructure Project Fund, deficit of $900,000 with a fund balance of $3,383,500. Fire District Number 3, deficit of $507,500 with a fund balance of $11,141,032. Fire District Number 1, sinking, a deficit of $101,000 with a fund balance of $45,656. Fire District Number 3, construction, surplus of $1,182,500 with a fund balance of $1,867,928. ACU Number 2, deficit of $1,325,500 with a fund balance of $997,038. Community Block Development Block Grant, deficit of $304,000 with a fund balance of $9. Hazard Mitigation Grant Fund, deficit of $922,000 with a fund balance of $120,430. Park Construction, surplus $162,000 with a fund balance of $508,754. ACUD Number 1, negative $267,000 with a fund balance of $67,121. ACUD Number 1 Sinking Fund, a surplus of $1,000 with a fund balance of $449,298. ACUD Number 1 Reserve Fund, 0, surplus of deficit with a fund balance of $60,028. Lighting District's Construction Fund, 0, surplus of deficit with a fund balance of $288,241. Parish Utilities of Ascension, operating surplus of $26,000, fund balance of $169,235. Whereas the proposed operating budget for the year 2019 includes revenues of $96,053,200 plus the required fund balance of $13,459,500 for a total of $109,512,700 in expenditures of $99,312,500. The capital budget includes revenues of $11,977,000 plus required fund balance of $88,918,500 for a total of $100,895,500 in expenditures of $110,864,000. Therefore, the total operating and capital budget revenue plus required fund balance equals $210,408,200 and expenditures equals $210,408,200. Interfund transfers or $49,939,500. Whereas the Ascension Parish Council has reviewed and considered such proposed budget and made revisions of the same, and whereas said budget was duly set after proper notice to the public for public hearing, which was held on November 15, 2018, as required by the revised statute of the State of Louisiana and Ascension Parish Home Rule Charter, therefore be it ordained by the Ascension Parish Council of the State of Louisiana that Section 1 of the 2018 budget, that the amended budgets prepared for 2018 are approved and appropriated by the Ascension Parish Council with the stipulation that transfer from the Sales and Use Tax District Number 1 to the General Fund, the Road and Bridge Fund, and the Parish Utilities of Ascension Fund in the amount necessary to maintain the balanced fund, but will not exceed the amount authorized in the budget. The Recreation Fund is allocated 10% of the net 1% Sales and Use Tax District Number 1 revenues as an additional source of funding. Funding is also provided by the allocation to the Sales and Use Tax District Number 1 Bond Sinking Fund and FINS, Families in Need of Services, to the extent that the resulting revenues of the Sales and Use Tax District Number 1 exceed expenditures and transfers, and after an adequate fund balance equal to 6 months of the expenditures is maintained, then such excess will be transferred 75% to the wastewater construction fund and 25% to the recreation fund. B, that 1/3 of the net of the Sales and Use Tax District Number 2 revenues collected for fire protection shall be shared by the Ascension Parish Fire Protection Districts Number 1 at 65%, by Ascension Parish Fire Protection District Number 2 at 13%, and by Ascension Parish Fire Protection District Number 3 by 22%. C, all expended appropriations will lapse at December 31st, 2018. Section 2, the 2019 budget, that the budget proposed for the year 2019 is approved, adopted, and appropriated with the following provisions. Expenditures not contemplated in the operation of the government of Ascension Parish as set forth in this budget are to be approved in accordance with the provisions of Article 7, Section 701 of the Home Rule Charter of the Parish of Ascension. Transfer from sales and use tax district number 1 to the general fund, the road and bridge fund, ACUD number 2 fund, the parish utilities of Ascension fund, and the amount necessary to maintain appropriate balance, but will not exceed the amount authorized in the budget. The recreation fund is allocated 10% of that 1% sales and use tax district number 1 revenues as an additional source of funding. Funding is also provided by an allocation to the sales and use tax district number 1 sinking fund and the FINS, Families in Need of Services, to the extent that the resulting revenues of the sales and use tax district number 1 exceed the expenditures and transfers, and after an adequate fund balance equal to 6 months of the expenditures is maintained, then such excess will be transferred 75% to the wastewater construction fund and 25% to the recreation fund. C, 1/3 net sales, 1/3 net of the sales and use tax district number 2 revenues collected for fire protection shall be shared by Ascension Parish Fire Protection District number 1 at 65%, by Ascension Parish Fire District Protection District number 2 at 13%, Ascension Parish Fire District Protection number 3 at 22%. Funding to be provided for the 2018 encumbrance is hereby approved and appropriated. All unexpected appropriations will lapse December 31st, 2019. The ordinance has been submitted to a vote. The vote thereon was as follows.
Thank you, Mr. Parrington. Got a motion by Councilman Todd Lambert, second by Councilman Cagnolati to open public hearing.
Motion to close.
Got a motion by Councilman Todd Lambert, second by Councilwoman Casso to close the public hearing. Got a motion by Councilman Benny Johnson to move the ordinance, second by Councilwoman Terry Casso. Any discussion? Any opposition? Hearing none, the ordinance is adopted. Item number 15, reading of ordinance to amend the Ascension Parish zoning map from mixed-use corridor MU to mobile home park RV district MHRV, lot F2 of a 22.930 acre tract and tract A1A, A2A for Foley Enterprises located on the south side of Lemonville Cutoff Road, approximately 900 feet east of LA Highway 3120, zoning review ID 1798.19. Mr. Parrington.
This ordinance amends the official zoning designation for Lot F2 for Foley Enterprises, Inc. from mixed-use corridor to mobile home park RV park district. This rezone is identified as zoning review ID PZ 1798.18, Lot F2 for Foley Enterprises, Inc. Whereas Ascension Parish is a local government subdivision defined by Article 6, Section 44, Louisiana Constitution 1974. Whereas the Parish of Ascension is the governing and responsible body over the zoning regulations within the jurisdiction. Whereas Article 6 of the Home Rule Charter of Ascension Parish adopted May 4th, 1993 identifies the process and manner in which to adopt ordinances regulating the lands of the parish. Whereas the official zoning map for Ascension Parish was last adopted March 8, 2016, and whereas the Parish Council reserves the authority to make changes to the official zoning map by ordinance. Whereas the request has been processed and is compliant with the procedures set forth. Be it ordained that the Ascension Parish governing authority, the official zoning map of Ascension Parish, Louisiana, is amended to reflect the property identified as Exhibit A as mobile home RV park district as the official zoning designation. In the event any portion of the ordinance is ever held invalid and unconstitutional for any reason by any court of competent jurisdiction over it, such portions shall be deemed separate, distinct, and independent provisions shall not affect the validity of remaining portions of the ordinance. This ordinance shall be in full effect as permitted by law. The exhibits are the legal description, the plat map, the aerial zoning map. This ordinance has been submitted to a vote. The vote thereon was as follows.
Public hearing.
Open public comment.
Got a motion by Councilman Satterley, second by Councilwoman Casso to open public hearing.
Close.
Got a motion by Councilman Joseph, second by Councilman Cagnolati to close the public hearing.
Motion accepted.
Got a motion by Councilman Joseph to move the ordinance, second by Councilwoman Casso. Discussion, opposition, hearing none. Ordinance is adopted. Item number 18. Reading of ordinance to amend the Ascension Parish zoning map from Conservation District to mixed-use corridors located on the north side of LA Highway 42, approximately 600 feet west of LA Highway 431, zoning review ID 1775.18. Mr. Parrington.
This ordinance amends the official zoning designation from conservation to mixed-use corridor This rezone is identified as zoning review ID PZ 1775.18, Louisiana Highway 442 and Louisiana Highway 431, whereas the Ascension Parish is a local government subdivision defined by Article 6, Section 44, Louisiana Constitution 1974, whereas the Parish of Ascension is the governing responsible body over the zoning and regulations within the jurisdiction. Whereas Article 6 of the Home Rule Charter of Ascension Parish adopted May 4th, 1993 identifies the process and manner to adopt ordinances regulating the lands of the parish. Whereas the official zoning map for Ascension Parish was last adopted on March 6, 2016, and whereas the Parish Council reserves the authority to make changes to the official zoning map by ordinance. This request has been processed whereas this process has been processed in compliance with procedures set forth. Be it ordained that by the Ascension Parish governing authority that the official zoning map of the Parish of Ascension is amended to reflect the property identified as Exhibit A as mixed use as the official zoning designation. In the event any portion of the ordinance is ever held invalid or unconstitutional for any reason by any court of competent jurisdiction over it, such portion shall be deemed separate, distinct, and independent provisions that shall not affect the validity of the remaining portions of the ordinance. This ordinance shall be in full effect as permitted by law. The exhibits are the plat map and the aerial zoning map. This ordinance has been submitted to a vote. The vote thereon was as follows.
Public hearing. Motion by Councilman Satterley, second by Councilman Lambert. Open the public hearing.
Motion to close.
Got a motion by Councilman Satterley, second by Councilwoman Castle to close the public hearing.
Move the ordinance.
Got a motion by Councilman Satterley, second by Councilman Dempsey Lambert to move the ordinance. Discussion. Any opposition? Ordinance is adopted. Item number 21, reading of ordinance to amend Chapter 18-11 of Ascension Parish Code of Ordinances, Subdivision 3, Public Sanitary Sewer, to add Section 18-117.5, Connection and Development Fees Availability. Mr. Parrington.
To amend Ascension Parish Code of Ordinances, Chapter 18, Political Subdivisions, Autonomous Boards, Commissions, and Authorities, Article 6, Consolidated Utilities District Division 2, General Sewage Ordinance, Subdivision 3, Public Sanitary Sewer, Sections 18-117.5, Connection and Development Fees Availability. Whereas Ascension Parish, the local government subdivision, is defined by Article 6, Section 44, Louisiana Constitution 1974. Whereas the Parish of Ascension is the governing and responsible body over the consolidated utility districts. Whereas Article 6 of the Home Rule Charter of Ascension Parish adopted May 4th, 1993 identifies the process and manner in which to adopt ordinances regulating the lands of the parish. Whereas the Code of Ordinances, Chapter 18, Article 11, was last amended on November 6, 2014. Now therefore be it ordained that by the Ascension Parish governing authority, the Code of Ordinances of Ascension Parish Board of Chapter 18, Political Subdivisions, Autonomous Boards, Commissions, and Authorities, Article 11, Consolidated Utilities District Division 2, General Sewer Ordinance Subdivision 3, Public Sanitary Sewer, Section 18-117.5, Connection and Development Fees Availability be amended as more fully described in Exhibit A attached here to and made a part hereof. In the event any portion of the ordinance is ever held invalid or unconstitutional for any reason by any court of competent jurisdiction over it, such portion shall be deemed separate, distinct, and independent provisions and shall not affect the validity of remaining portions of the ordinance. This ordinance shall have full effect as printed by law. The ordinance has been submitted to a vote. The vote thereon was as follows.
Open public comment.
Got a motion by Councilman Cluett, second by Councilman Satterley. Open public hearing.
Motion to close.
Got a motion by Councilman Lawler to close the public hearing, second by Councilman Cluett. Public hearing is closed.
Motion to move.
Got a motion by Councilman Cluett to move the ordinance, second by Councilman Satterley. Any discussion? Any opposition? Motion is adopted. Item number 24, executive session, discussion of the following: pending litigation and claims pursuant to L.A. Revised Statute 42:17A2A, public records lawsuit by Parish of Ascension, B. T. Wesley, suit number 123.215, B. Texas Workforce Commission Unemployment Benefit Matter, R.E. Toledo F. Wesley, claim number 340063, C. Ascension Parish v. Toledo Wesley, injunction lawsuit number 123.788, Division C. Executive session. Got a motion by Councilman Cagnolati, second by Councilwoman Casso to go into executive session. Please open the voting machines. Hey, please close the voting machines. Voting machines closed. Motion is adopted unanimously. Go into executive session.
to reconvene.
A motion by Councilman Lawler, second by Councilman Kluat to reconvene. Any opposition? Back in session. Item number 25, employee appeal of employment-related decisions. Each appeal item will be addressed separately in accordance with council procedures for such appeals. I have a document to read in preparation of this, rather lengthy, so be patient. This is regarding the Wesley appeal hearing, the procedure. Item number 25 on the agenda are appeals by Toledo Wesley of 2 employment-related decisions made by the parish president. The first decision is a termination dated September 12, 2018. The second decision is a reprimand dated September 12, 2018. Upon receiving these 2 employment-related decisions, Toledo Wesley exercised her right under Section 5-04 of the Parish Home Rule Charter and appealed the decisions to the HR Review Board. The HR Review Board convened on October 9, 2018 to consider Toledo Wesley's appeals. After considering the evidence elicited at the hearing, the HR Review Board sent a letter dated October 10, 2018 to the parish president stating, quote, the HR Review Board, with only 4 members present, came to a tie vote. Therefore, the board has no recommendation on either issue appealed. After receiving the HR Review Board's decision, the president reaffirmed his decision, uphold the reprimand and termination. Toledo Wesley has appealed to the council the president's decision to reaffirm the president's decisions. Normally, matters discussing the character, professional competence, or physical or mental health of a person and investigations of misconduct are conducted in executive session as provided by Louisiana Revised Statute 42:17-1. However, Toledo Wesley has elected to have this hearing in open forum, which is her choice. Ms. Wesley wanted to confirm that that is your choice. Is that still your choice? Is that correct?
Yes, sir.
Thank you. Ms. Wesley, although you have chosen to have the matter heard in open forum, this does not authorize you to discuss the character, professional competence, or physical or mental health of persons who are not a party to this appeal. That includes parish employees and any other third parties. If you attempt to do so, I will stop you from discussing these matters. I'm also making this same instruction to the parties' witnesses, their attorneys, the parish council members, and to everyone in public. Moreover, there is information which forms the basis of an appeal that is highly confidential and protected by federal, state, and parish laws, including, but not limited to, the following. A, Louisiana Constitutional, Article 1, Section 5, which guarantees citizens the right to be secure in his person, property, communication, houses, papers, and effects against unreasonable searches, seizures, or invasions of privacy. B, Louisiana Revised Statute 44:11D, which deems confidential and protected medical records, claim forms, insurance applications, requests for the payment of benefits, and all other health records of public employees, public officials, and their dependents in the personnel records of any public body. C, the Health Insurance Portability and Accountability Act, HIPAA, 45 CFR 164.500 et seq., which prevents the disclosure of protected health information. D, the record-keeping requirements set forth in 29 CFR section 825.500 relative to family medical leave, 29 USC 2601 et seq. E, Section 2A1C of the Ascension Parish Policy Manual, which states that the contents of an employee's personnel file shall not be divulged to third parties without the express written consent of the Human Resources Director or employees, except when ordered by a court or by subpoena in accordance with this rule. F, Section 2A3 of the Ascension Parish Personnel Policy Manual, which provides for the security of personnel files. Should anyone even attempt to discuss information which is protected by any of these foregoing laws, I will stop you from discussing that matter. Moreover, Ms. Wesley, although it may be appropriate for you to discuss conduct of your immediate supervisor and the parish president, it is not appropriate for you to discuss third-party employees, especially legally protected information about those third-party employees. Specifically, you are not to discuss A, the identity of any third-party employee who is not a party to this hearing, B, the position that the third-party employee held, C, or the department that the third party worked in. Should you or anyone here attempt to do so, I will stop you from discussing this matter. If anyone here does not know whether a particular question or topic should be addressed, or whether a particular person's name should be mentioned out loud in this public forum, then please approach me or the parish council's attorney, O'Neill Parrington, and consult with us privately. Mr. Parrington or I will then let you know whether the topic, question, or person's name can be mentioned out loud in this open forum. With that said, let's now discuss how this appeal hearing is to be conducted. The council is tasked with deciding whether to, 1, affirm or overturn the president's decision to terminate Toledo Wesley, and 2, affirm or overturn the president's decision to reprimand Toledo Wesley. It's important to note that the only evidence the council can consider in this evidence that was or should have been available to the parish president when he made his final decisions on the disciplinary actions at issue on this appeal. The council members are specifically instructed that they are not to perform their own investigation and they are not to bring other evidence into this chamber. For each of the disciplinary actions being appealed, 1, appellant Toledo Wesley shall have 10 minutes to present supporting evidence to overturn the recommendation of the HR Review Board and the action of the parish president. The evidence shall be consistent with the evidence produced at the HR Review hearing. 2, the parish president or his or her representative shall have 10 minutes to present evidence supporting the decision by the parish president. 3, and Toledo Wesley shall then have 5 minutes for rebuttal. The floor shall then be open for questions from council members. After questions from council members are conducted, the floor shall be open only for a motion to overturn the parish president's decision. If no such motion is to overturn is properly made and seconded, then the parish president's decision stands. If a motion is properly made with a second, then 2/3 of the members present must vote in favor of the motion to overturn in order for the decision of the parish president to be overturned. A roll call vote will be taken. Now we will move to 25, item A, appeal of Toledo Wesley termination. And Ms. Wesley, you have 10 minutes. Now this will not be.
I actually have some questions that I'd like to discuss with the council and the parish attorney as you suggest.
Okay. So go ahead. What's the
regarding I don't have the document you just read in front of me, but regarding the
Ms. McKee, can you
position.
get her a copy of that document? Okay. Not yet.
where you mentioned it is not appropriate for you to discuss third-party employees, especially legally protected information of those third-party employees, the identity of those employees, and what do you mean by third-party?
Those are people that are not employed by the parish.
What does not employed mean? Could you clarify?
It means they don't work for the parish. They don't.
Contracted contractors work for the parish.
I was saying about it's not a party to this.
Right.
Yeah. They can work for the parish. They're just not a party to this.
I'm sorry.
Potential litigation.
I'm sorry. Okay, so I'll let Mr. Parrington. Mr. Parrington, would you answer that?
You can't disclose other people's private information that's protected. They didn't request an open hearing.
So you're talking about
and where's that located?
That is in the open meetings matter.
Could you provide the number and the information for that?
He read it in the instruction. It's the open meetings law, which says you have chosen to have your hearing in public, but to discuss the competency or the et cetera of another public employee, they're not in an open meeting.
I'm sorry, it doesn't list the ordinance or the revised statute for that.
Louisiana Revised Statute 4217 says you cannot discuss the character, the professional competence, or physical or mental health of a public employee.
And is that quoted?
That is the law that we provide. I emailed you a copy to this today. I emailed a copy to Mr. Fifi. That is the law.
You emailed something to me
Yes.
today
Yes.
and expected me to be prepared for today? For open,
Was this,
for open meetings?
So we're gonna move along. If you want us, I think Mr. Parrington has answered your question. Do you have another question? He cited the law here.
I believe it's incorrect.
Okay. So do you have another question?
No, sir.
Okay, so you now have 10 minutes. Are you ready to start your,
I would actually like to do a motion to extend my time limits or to combine.
well, I'm sorry, what, are you requesting more time?
Yes, sir,
What's the request?
for more time.
So how much time?
Or to combine an additional 10 minutes on each subject?
So you'd have 20 minutes?
Yes, sir.
On each subject?
Yes, sir.
And then the 5-minute, you have a 5-minute rebuttal too?
Yes, sir.
Okay, I'll give you 15 on each one, so you got 15 minutes. And the clock has started.
Okay. I'd like to begin by thanking Mr. Mike McClanahan of the State NAACP, parish employees, and local parishioners who are watching. Also thank them for their calls of support over the last few months. We're discussing the disciplinary action, correct?
This is your termination.
This is my
Item number,
termination.
the first item is the termination.
Okay, that's a bit out of order.
That's the order on the agenda.
Okay. Could we do a motion to switch? Because with the,
We can't change the agenda? Okay.
Are you sure, sir?
I'm not willing to change the agenda.
Okay, thank you. Okay. So, I'd like to first start by addressing the coaching documents in my file. A coaching is a method used to improve an employee's skills, which is different from a disciplinary action, which shows that something has been done against policy and gives guidance on how to correct it. With both of the coachings, the incidents happened weeks prior to, which is against best practices, but were insisted upon by the parish president. I received both of the documents on the same day. The first being the employee referral. An employee was terminated. I heard that a company nearby may be hiring, and I called to see if it were true. I relayed that information to an employee, the employee. I never gave a recommendation to the prospective employer. The employee was a good family man who just made a dumb mistake. His employment needs were immediate, and there's not a policy that states that such conversations nor recommendations, which I did not give, could not take place. The second coaching was for my performance at an employee appeal to the council. Let it be stated that the council has not published nor placed into ordinance its rules of appeal. Although the parish president's representatives are typically happy to remind you that I'm not an attorney, and they're correct, I am a law school graduate, and I was attempting to prevent the parish president from perjuring himself in front of the council. I apologize for any dissatisfaction. I actually called each one of you or met with each one of you outside that particular meeting. And some of the response that I received back was that you apologized as well for the lack of decorum in the order of the meeting. Those council persons promised to get the rules reviewed and conduct the meetings to the standard set. In my coaching, I was asked to prepare a procedure to conduct executive sessions for the council. I submitted those documents to the council chair and was awaiting a response before moving forward with internal training for the employees. Now, in these particular documents, the CAO was clear to state during that meeting with me that these were coachings and not disciplinary documents, and that is why they're on two separate forms, okay? And they're not on the disciplinary document form. Otherwise, I would have appealed this particular action to the HR Review Board. Now let's talk about my performance. During the disciplinary meeting regarding the benefits manager's demotion, Mr. Ken Dawson stated that the parish president wanted my resignation. However, when he asked the parish president why, he couldn't state the reasons. At 4 p.m. on the 12th, I was asked to report to Gonzales, where I received the termination document stating that it was because of his evaluation and assessment of my performance. I have not seen such evaluation nor met with the parish president regarding my performance. If you notice on my offer letter, which was submitted to you, I was to receive an increase should my performance be positive. I received that increase plus an additional increase earlier in the year. After my erroneous disciplinary document was delivered to me, the parish president spent 3 hours with parish representatives telling him not to fire me. He did so anyway. I then received unemployment documents that said that, and you should have that as well, they didn't say that it was because of unsatisfactory performance. It said insubordination. The state decided I didn't do anything wrong, and they gave me my unemployment. So the parish president can't make up his mind on what he could say to remove me from my position. But I couldn't ask him that at the HR Review Board because, once again, derelict his duties. He wasn't present. Prior to my termination, I was placed under the supervision of the currently acting assistant director, which was against a recent ordinance passed by this council that states that an unratified employee shall not have supervision over a ratified employee. I have not received poor statements from my supervisor, the acting director, nor the CAO. The attorneys present would have you believe that the CAO was the person who counseled and disciplined me. However, it was the parish president that asked him to do so. The parish president has for months refused to, nor neither, respond to my calls. He has declined to meet with me or failed to show up for meetings about my department. Around that same time, the parish president, through the CAO, directed me to operate entirely through the Donaldsonville office, which was difficult because most of the internal employee issues were in Gonzales. He also took the satellite office in Gonzales away from us and the use of the pool vehicle. My focus has been on fixing the problems of the past administrations and working on the future of the department through its multiple projects. Many of the projects have been delayed due to manpower issues, shifting priorities, lack of technology, lack of training, lack of a proper location in Gonzales so employees can have easy access to us. Our Donaldsonville office has mold in the AC vents, insects, and desks that are held together by office tape. while other employees, other personnel are in safe environments. The HR department received permission from the state archives to destroy over 50 boxes of purged documents that were irresponsibly retained since police jury days. And that's just some of the things that I was going through. Menial tasks would take hours or days because it had to be created from scratch. A job analysis of my staff showed that they were being asked to complete 80 hours of work in a 40-hour work week. The analysis was supported by submittals to the parish president and the CAO by a consulting firm. In March, I requested 2 new employees after one was being transferred to another location due to performance. After a month of sitting on our recommendation, I was finally allowed to hire one person. The second posting for an HR role was up for over 4 months, in which qualified individuals were interviewed and recommendations sent to the parish president. He never responded, even after several follow-ups. Once again, it is curious that the recommendations to shift the office personnel for better efficiency were approved after I was terminated. I've been riddled with shifting priorities. The parish council placed administration to task with developing job descriptions and a performance review process. Many of the job descriptions were missing or inadequate. The assistant director assisted me in meeting with department leaders to understand what was needed to update or create a job description. A simple task that was continuously complicated by interruptions, changing agendas, and a lack of organization charts. The parish president directed us not to distribute organizational charts. Many of the departments shifted employees so often that neither the HR department nor the employees knew who they were reporting to. Leaders have no say, or for some, too much say, for those particular chosen few, in who are in their departments and what the employee will be doing. The culture is that the employees will tell the leaders what they will or won't do without failing to use profanity to describe their dissatisfaction in front of their teams. The culture is also feelings of fear, feelings of contempt for missed opportunities of promotion with no clear guidance for the future. I knew that the measures the council placed upon us was not only daunting, but also necessary in order to outline what an employee's duties were, create a mechanism for advancement, and to support leaders in coaching. However, other priorities, as delivered by the parish president, came before this required task. That is why I pushed to have a contractor take over the task. Parish employees required training in all aspects of this multi-million-dollar business. I will conduct ethics and the first few new hire orientation that the parish had held in over a year. A company was also contracted in to provide training on over 12,000 topics necessary to prepare employees for advancement. This was the first step in creating what I call Ascension University, which would encompass online, field, and classroom training. Leadership courses will also be being prepared to assist with career counseling, coaching skills, and general organizational development. I made sure employees were able to organize their benefits by having representatives from benefit management companies speak to the employees on a monthly basis. Weekly meetings were also scheduled with the HR and safety team. That hadn't happened prior to me coming. There were no meetings with our teams. I created and met with the Personnel Manual Committee, which consisted of leaders, employees, and council. Weeks and hours were spent in meetings having healthy debates about the future culture of the parish. That document is now with the parish. I also created a sick leave donation program, which has been successful for those employees who have chosen to participate. I would be remiss if I didn't remind the council and constituents that human resources was not the only department under my supervision. I directed the understaffed safety department of one. When I arrived at the parish, the employee in that department had no certifications, hadn't had them for 5 to 10 years. I sent him to get his certification. safety meetings would now be held every month with intentions on moving to once a week. Parish buildings have no records of in-house inspections, nor any completed on a monthly basis. And that was also one of the target things that we were working on.
So, Ms. Wesley, you have about 2 minutes. Just
Are
a
you
little
serious? Well,
reminder.
let me get to the bottom of it. They're going to come in here and say that this is at will. At will. I really wish the meter was working. But it's not at will if the cause is illegal. Okay? The first cause, the first thing that makes it illegal is that it's retaliation. It's retaliation because I brought forth fraud and illegal activities by the parish. And I made sure that the parish president and CAO was aware of those particular things. That's insurance fraud, benefits fraud, issues with I-9s that are federal documents. We have 1,100 employees in the parish. 80% of the I-9s are missing or incomplete. That means that federal funds are taken away and $800,000 in fines plus. Another thing was race. If you recall, when you went out for the position, the parish president asked that you go back out several times when black women came to the forefront. It was only with your insistence that I was hired. And there are several examples of when he's protecting other employees other than me, other than blacks. For example,
so I have to
firing
ask you to wrap up.
Okay. Well, the greatest thing is that I'm here for the parish. I'm not here for anyone in particular other than the parish constituents. And there are many things that are wrong with the parish, but it's things that I'm working toward. It's things that my team was working toward. And this termination is only retaliation and discrimination based.
Okay, thank you, Ms. Wesley. Now we'll have, and I will allow 15 minutes for the parish president or his or her representative, and it looks like that's going to be Mr. Diaz. So the same, Mr. Diaz, you'll have 15 minutes, beginning now.
Thank you very much. Good evening, Councilman, Chairman, Parish President. I've been involved with this case for 2 months now, and I want to get something off my chest before we even get started. This is the first I've heard of retaliation. This is the first I've heard of race. This is the first I've heard of gender. And I'm embarrassed that we come here tonight after going through meetings and emails and communications and a hearing, and I've never heard those things till tonight. I'm kind of at a disadvantage because we've terminated the HR director. And you would think the HR director, in fact, I felt I've been at a disadvantage for a week now because you would think she would know her personnel manual that she's charged with enforcing backwards and forwards, upside down, right side up. But she apparently doesn't because this guy's is and I don't need 15 minutes. I need about 1. Because this is a classic at-will employment case. We are a classic at-will employment parish. It's the first sentence on page 9, and it says, employment with Ascension Parish is at will. What does that mean? It means that we can terminate you or anybody. Look, termination cases are difficult. In fact, about the only time you guys ever see me, O'Neill, is when it's a difficult case involving a termination or something else. But termination cases are difficult to begin with, but this is not a difficult case because it's a simple case involving at-will termination where somebody just doesn't work out, the bloom falls off the rose, it's not working, people are not happy, somebody's got to go. And that's what happened. You terminate for at will for any reason, with or without cause, at any time. Now, you could come in here tonight and make up all that you want to make up, all these new reasons we've never heard before, race, retaliation, gender. None of that's been mentioned before tonight. That blows my mind because Miss Wesley is a lawyer. She's not a practicing lawyer, but she does have a law degree. Very intelligent lady. Has a lawyer with her, Mr. Fifi, who was at the hearing. Sat at the hearing. He may not be a lawyer tonight, but he's here, and he's been following her notes, so he's helped her with the case. But the point is this, is that we're not dealing with somebody who is not intelligent, who doesn't know how the system works, who had a chance to bring all of that up 2 months ago, 1 month ago, 2 weeks ago, in an email yesterday, and never did. So I don't come here tonight to talk about whether it's about retaliation, because it's not. I don't come here to talk about whether it's race, because it's not. I don't come here to talk about whether it's gender, because it's not. I come here to talk about what it is. It's an at-will and termination. She just didn't make the grade. She's been here a year. She's gone through a lot. In fact, I hate to say this, the stuff she was talking about she had done almost proved the reason why she should be terminated. Because all that stuff started, but it never stopped. It started, it never got to completion. The HR department was in chaos. And as a result, she was terminated. If you look 3 times in Miss Wesley's Bible, the Parish Personnel Manual, it talks about at-will employment. That's why I was expecting to see more of it. Likewise, the parish may discharge employees at will, with or without cause, and at any time. That's on page 62. So we got page 9, page 62, and then we flip to page 69. The parish may terminate employment with or without cause. The following are examples, but they're not what's required here. It's just an at-will termination. We have the benefit as lawyers, and there are several in the room. In fact, I think she also introduced one. But we have the benefit as lawyers of looking at Louisiana court cases. And those things are helpful because they guide why we're here. They guide why decisions are made. And this is a case, this is a 2016 case, fairly recent, 2 years ago. And it says, an at-will employee may be terminated. This is from a judge, by the way, guys. It's in Jeff Diaz. It isn't Miss Wesley. It isn't Mr. Fifi. It isn't Parish President Matassa. An at-will employee may be terminated without assigning any reason for doing so. The reasons for termination need not be accurate. They need not be fair. They need not be reasonable. In fact, there need not be any reason at all for termination. Our parish president decided that in his administration, Miss Wesley wasn't working out. And as a result, not for reasons based on retaliation, for what I have no clue, not for reasons based on race and not for reasons based on gender, but for reasons of her performance being unsatisfactory, he made a decision to terminate her. And that's what he did. And your decision is real simple. Either you bring her back on in the same department, in the same position, or you honor his decision. And we simply ask that based on what I've heard tonight, and based on what I've heard for 2 months, that you uphold his decision and you terminate her for her at-will employment. If you have any questions of me, I'll be happy to answer them.
So we have a period for questions at the end, Mr. Diaz, but thank you. And Ms. Wesley will have an additional 5 minutes.
Okay, thank you. The first thing that I want to say, again, at will doesn't mean at will if it's illegal. I did report the parish president to the ethics board, and they're currently looking at his case.
An ethics complaint is not public.
It actually is.
No,
You
it's
can
not,
request
ma'am.
it. You can request it. If, anyway, it's currently being reviewed right now. And it is also matters of the I-9s that reported to the federal government that I had no choice but to report. There were matters of fraud in my department that he's protecting a white employee. Same thing with race. He fired a black employee and kept a white employee for the same manner in which the black employee had more tenure for extended leave than the white employee. Okay, so there's many matters that I'd like to, really would like to discuss with you guys, but if it's illegal, it's not at will.
So you have about a little over 3 minutes.
Okay. And there's been a lot that this parish president has done to try to kind of damage my my character. He said that the consulting agency didn't do their due diligence when hiring me. That's incorrect. It's in my files. I had gleaming reports from my previous employers telling employees that I was against them, telling employees not to speak with the HR department. So some of the reasons and the challenges that the HR department was in chaos when I arrived, and it's gotten better and improved not only through the services that the employees received, but also through the internal trainings that the employees, that the HR department received. So going back to race, he asked twice that the position be reposted. Each time black women came to the top, there through the council's encouragement, I was hired. Conversations since then have been somewhat sporadic. If you have to look at the demographics of Ascension Parish, 73% white and 22% black, with other being the remainders. Only 3 black people hold top positions in this parish. When a white leader has an issue or performance or conduct, the parish president steps up to preserve their jobs. An employee damaging property against the parish personnel manual, which, yes, I do know, should be sent for a drug screen. He calls the employee and have them come back from their home to come back to work. No issue. My employee, who clearly violated state law by fraudulently taking and giving benefits to employees, ignored. White. Fired a black employee for extended benefits leave, but refused to do the same thing with a white one. Telling me to hire a convicted a person convicted of severe crimes, violent crimes, who'd be working directly with the public. White, but had no problem when a black person has issues getting hired on. Finance leaders being told time and time again from state auditors that there were problems after correcting. And these are years. White, no issue. All of a sudden, someone that's coming in, making changes, progressing the department and the parish forward, there's an issue. Even after no performance discussions with me, whether through the CAO or my illegal acting director, the current acting director, really, there was a witch hunt from me because I'm black. Some of the issues we had with illegal activity. Local insurance company hired to be our...
So I'm going to have to ask you to wrap up.
Okay. Again, at will does not mean at will if it's illegal. And, you know, I have more instances. I wish I had more time. And these are, you know, anyway, they'll come forward. Thank you.
Okay, thank you. So now we will have That's all the evidence presentation. So the floor be open for questions by the council members. So, any council members having any questions for either one of the witnesses or parties? Mr. Satterley.
Yes, and Mr. Chair, are we going to have just one round of questionings, or if other questions come up that other councilmen or council members may bring up?
I'll be patient.
Thank you, sir. I'll try. It's been a long night to be as brief as possible as well. I'd like to ask three sort of questions and then make points of them for the record. First off is, who authored the document in our packets that you as Chair Bill read into the record as the ground rules for how we are to proceed tonight?
That was done by a combination of the attorneys for the parish.
Okay, that's good. That's what I was hoping. Number two, do we as a council have all the information that the HR Review Board had in making their decision of a 2-2 tie at their review board hearing? In our packets, do we have all that?
Mr. Parrington will answer. I didn't participate in that.
I didn't participate in the packet, but that was the packet that was provided to the HR Review Board.
Okay, and as a follow-up to number two, Ms. Wesley would have had the same email. Well,
that was provided at that HR hearing.
Okay. And then finally, number three, Mr. Chairman, if you will, for the record, Ms. Wesley had beforehand of this appeal hearing tonight this three-page chairman's that I mentioned in point number one, instructions on how we're going to proceed, and then all the information in our council packet, not just because there are other things, the HR review information, which I want to address next. Is that correct?
So the three-page document was emailed. Now, whether, we didn't get a verification of delivery of that.
Okay. So one somebody certified.
Correct. That's
I did not receive.
So you're alleging you didn't receive it?
I did not receive, no,
We don't
sir.
have proof one way or another here tonight. Okay. All right, let's dive in. Ms. Wesley, you have in your introductory remarks talked about there's a difference between coaching and disciplinary action. The former being, I think I captured my notes, to improve an employee's performance, and the latter to chastise them for doing some more grievous offense. How long have you been employed by this parish?
1 year, 1 month.
Okay. Is it a requirement that you be evaluated on a year-to-year basis?
According to the handbook, yes.
Have you been evaluated?
No, sir.
So can I interpret, not seeing anything like that in my packet, that you were never evaluated prior to the September 12, I'm going to say not incidents, plural, because I believe reading what was written by the chairman of the HR Review Board on September 12, it says Ms. Wesley submitted an appeal request for a written disciplinary action and later the same day for her termination of employment. That's correct.
I'm sorry.
Both of those events happened on the 12th, and that's the first time you were told by administration or anyone that you're not performing very well. All right, let's dive into it. It says, according from what the review board found out, that the summary for your written disciplinary action had to do with the fact, I assume this is fact, that you actually issued a disciplinary action recommendation of a demotion of an unidentified employee, keeping with the ground rules, within your department in terms of a personnel action form, which you forwarded to the parish president, but before he signed off on it, you allegedly acted on that PAF, personnel action form, by, it says, unilaterally making changes to the employee's status as if the demotion had been approved, and that the failure, therefore, for you to wait for Mr. Matassa and what decision he would make in this matter amounts to insubordination and failure to follow, it says, long organized procedures and customs in the parish. Kind of danced around this, but how do you respond to that directly?
Well, one, I made sure that I wasn't alone in any of these conversations. So the CAO and my assistant director was with me. All of the communication was discussed through the CAO because, again, the parish president refused to meet with me. But I did receive confirmation from the CAO.
But it says it was forwarded to the parish president in our document here.
The PAF goes from my office directly to the parish president.
But you're saying Mr. Dawson acted on it.
On the
Are you? I'm not trying to put words in your mouth. I'm trying to
No.
understand what happened.
Okay, so what happens is if there's an event to take place, whether it's a change in pay, change in role, a PAF is created as a record of that particular change. Changes may have happened a week prior to. It may happen a week later. For example, he's given people positions and placed them in the position. HR finds out later, and the paperwork gets completed. This is a similar situation where the discussions had been had. The parish president via the CAO had approved all of the changes, and those changes were made.
So what,
a PAF was completed.
It says that you recommended a demotion. That would mean that you wanted this to happen. Is that correct?
My initial recommendation, because of the fraud, was for separation.
What fraud? I don't know anything about any fraud.
I have to be careful here.
That person was.
And be careful.
I'm going to attempt to. That person was giving away benefits, was had not enrolled people into their benefits, giving them undue benefits, and it was such a mess. And additional things had happened behind the scenes.
Where are we at legally?
Okay, let's be careful.
But either way, the conversation had been had and approved.
I agree with Mr.
prior
Claude here. We need to be careful. So let's move on to number 2. The second part, besides the written disciplinary action, besides it may be the only thing relevant. After all, we had Mr. Diaz come up here a moment ago. We've heard Mr. Parrington say this in the past, and I'm going to quote Mr. Diaz. It may not have been reasonable for you to be terminated, but kind of so what? It's at will. So this at will thing seems to be really as captured in number 2 in the appeals procedure. And I'd like to put this in the record. The summary for the reason for separation, and I assume that's a term meaning termination, the synonym for that, is that the parish personnel policy manual on page 9 specifically states, quote, employment of a parish Ascension is quote unquote at will. As such, the employment working relationship of any person with the parish may be terminated, quote, at any time and for any reason, unquote. Page 69 further states the parish may terminate your, quote, employee with or without cause. Now, that would have been fine if it would have stopped, but what troubles me is the next paragraph. And I'm referring to the October 9th, 2018. I asked this previously. This is in the public record now because it's in our packets. There was no one specific incident for the recommendation of termination. Let me repeat that. There was no one specific incident. This was the fact-finding body that we have interfaced between the parish president making his decision and us here tonight on appeal, the HR appeals board, saying that no specific reason for the recommendation of termination. Rather, it states it was the review of the sum total of her work and work history with the parish. So, and it's not in the best interest, it was determined for the parish of Ascension, it was in the best interest, to terminate Ms. Wesley's employment immediately. Now, that brings me back to the comment about the required evaluation. How is it that if there's no specific incident, that must include then the written disciplinary action under number 1, or any other ones, and you're saying prior to that there's nothing in your file and you were never ever reviewed, so I don't know how to make my mind up. Have you been an exemplary employee up until these allegations or not? Because it's saying pretty much here, whether it's just in the best interest of the parish for an undetermined stated reason, and then with that, quite frankly, I'm not sure if I blame the board for that. It's a 2-2 tie. Did I get anything wrong?
Well, he couldn't exactly say, I'm retaliating against her for bringing up illegal activities that I participated in, or that I never really wanted a black person at the top of that particular department. So I wouldn't be surprised that the language that he used was very generic and unconvincingly bland.
Okay, so moving along then, in our packet is September 12th, 2018, a letter, I guess, from our CAO a issuing supervisor on, it says it's on behalf of Kenny Matassa, the parish president, recommending immediate termination of you, and it goes through all that stuff. I won't read it again on page 9 and so forth of our Ascension Parish Personnel Manual as it relates to, termination at any time for any reason without cause, with or without cause. But the second paragraph reads, and I quote, "In making this recommendation, I have taken," that would be our CAO, "into account your employment history." So there's undetermined things there, say undetermined, there's undescribed things there. As our AP HR director, in my evaluation assessment, you simply have not displayed satisfactory performance. Again, I don't know how I can assess that. And the accomplishments on your job, on the job as the parish HR director. Please note, I am not pointing to, and there it is, or using one specific incident as the reason for this termination, for this recommendation, which is for termination. Rather, it is my review of the sum total, there it is again, of the work history, which I don't have, with the parish. It simply is not working out, and based thereon, in my opinion, it is in the best interest of the parish that your employment be immediately terminated.
And that document was created by his attorneys.
Well, I didn't ask that, but thanks for letting us know. So, again, is there any documentation in the files, and I can ask that also to Mr. Matassa, I believe that's okay in the ground rules, Mr. Chairman, as to how you have performed prior to this disciplinary action and the at-will termination. And there's one more thing in here, and I'll be brief about it. It also talks about that you were insubordinate doing a private executive session. In terms of council people, it alleges in here, came forward and said that they didn't like the way you treated certain council members. And I'll go on record to say, myself included. I'll also go on the record to say that you have called me about this personally, and you apologized for your behavior that night and so forth. But, and again, I don't know if that's factored in heavily into this decision or not. But, that did happen. You said, quote, "Let's talk about my performance." Okay, again, that's back to the reasons. Have you been, I've already asked you that, evaluated before. It's always the same question comes up in my mind. You allege that Mr. Matassa did not return any calls to you when all this was going on or respond to any of your emails. Do you have any examples that you could give this council tonight of these alleged emails that he didn't respond to?
That is currently in litigation. I'm attempting to receive those.
Well, but they would just
documents.
be asking me tonight, I got to make a decision. That's not going to help me. I mean, those things either exist or they don't.
They do exist, yes, sir.
Well, okay, if you say they do, I don't know what to say about that. My last and final question, and thank you for your patience, Mr. Chair. The I-9s you specifically made, you said 80% are missing, and this could result in the loss of federal funding if detected. And then you followed up later and said, quote, "You have no choice but not to report that." Why do you have no choice but not to report that?
Because it's required by the federal government that we report so that they can assist us in getting it corrected.
Any other consequences if that information is being hidden from the federal government?
Severe consequences, actually. And some of those things, if they find it themselves, if they come through and do an audit and find it themselves, then, that's when you see your FEMA funding taken away, your housing funding
So do you
taken
believe
away.
that had anything to do with your firing?
Yes, because he was upset that I actually presented it in the personnel committee meeting and to the council as well.
Mr. Matassa, do you want to respond to that?
The file she's talking about is HR files, and that was the first I had heard of it. And they do have a lot of documents that are missing today from HR department.
I was more or less asking though, or do we have problems with? She's alleging that 80% of the employees we don't have I-9 information on. Is that correct? Do you want to state that that's correct tonight or not?
I can say, Councilman, that yes, Ms. Wesley did talk about the I-9s. informed that there were definitely some discrepancies, some problems with him. Also, and one thing we always talked about was the burden on the HR department, all the things that we had to do. So in looking at that, we looked at all of the things, and I think that some of these things, just to go back a bit, were not anything that were foreign to what SSA had pointed out as well. So the goal was, how do we attack that in the most efficient and effective manner? The method that we discussed was that there is no way with the current staffing of HR that we could possibly do it, so we were looking at to see if there would be additional outside assistance that could come in and take something that would be deliverable, that would not be ongoing, that can get it done and set it and, you know, and just say, here it is, we got this particular item accomplished. That was the direction that we were heading in and trying to, you know, trying to move in that path.
And thank you, Ken. And Mr. Dawson, for the record, going back to your letter of September 12th, I mentioned earlier, 2018, where it says that you were acting on behalf of President Matassa in describing why Ms. Wesley was fired. What do you want to tell this council tonight? Was she fired just because of that will? Was she fired for any specific reason? Do you stand by, you know, the sentence in there where you state that there's been an employment history, which I'm saying tonight is undocumented, as the Ascension Parish HR Director, that's, you know, it's been substandard, it's displayed that's lack of satisfactory performance, accomplishment of job task. It's sort of like dances at, there are some specifics, but I'm not going to name them, it's at will. And that question would go either for you or for Mr. Matassa if he chose to answer, chooses to answer.
My decision to fire Ms. Toledo Wesley was based on overall performance issues as discussed in the disciplinary record, and not one matter, not just one thing. It was a number of things. Thank you.
And are you willing to be specific about what those number of things are?
It was all spelled out in a disciplinary action.
I beg to differ in terms of what I read in there is it said it wasn't one thing. It said it was, you know, it's an overall history, but yet there's, and it's at will. I'm just really having trouble getting my arms around why is she being fired?
Well, I just told you it was a number of things, and if you put them all together, I made my decision to fire her. I made a decision on the 11th. I gave the task to fire her to Mr. Dawson to either resign or be fired. And then on the 12th, that's
so it
when
wasn't at will. It was because of a number of things. Are you saying those number of things
it was
are
at will.
my will? I'm sorry, sir.
It was at will.
Thank you, Mr. Chairman. I don't have any more questions.
Okay. Councilman Turner.
Yeah, I just have one question as of right now. I know we have quite a few attorneys here for the parish, so I just need to know, as far as Louisiana Revised Statute 42-1169, how does this relate to Ms. Wesley?
Mr. Diaz, or?
The whistleblower statute. Well, she made some whistleblower claims when she spoke, so I need some clarification on how does that relate to the issue she spoke on.
Had the whistle been blown?
So come to the microphone, Mr. Diaz, please.
This is a fascinating discussion. No whistle has been blown.
Well, hold on. I don't mean to cut you off and be rude.
Okay.
My question is the allegation she made tonight. How does that relate to the whistleblower statute? I'm not concerned about all this other. She didn't make the hearing, make this before today or yesterday or in a hearing 2 months ago, because we got a document. She got a document today that's being enforced today. So my question is, as we sit here today, how does the claim she made relate to the whistleblower statute?
Let me try to answer that like this. She hasn't made a claim with anybody.
She just made them tonight.
Oh, well, no, you can't come here tonight
and
say,
hold on.
You've been fired, and say, oh, Bob,
when I read the statute, well, let me read the statute. When I read the statute myself, Louisiana law protects public employees who report information which they reasonably believe is a violation of any provision of law or any other acts of impropriety related to the scope or duties of public employment to the agency heads. So she can report it to anybody that's over her, to the Louisiana Board of Ethics, or any person or entity of competent authority or jurisdiction. So being that she did report the I-9s and some of those other things being done incorrectly, she did create a whistleblower statute issue. So I need that response. As far as what she claimed as far as the I-9 and what other improprieties that was done, that was going on in the parish, that she did report to her superiors or to any entity or person of competent authority for the parish.
Well, that's where we have a disagreement, because she has not reported that.
She just stated quite a few times she reported to Mr. Patassa or Mr. Dawson or
No,
whoever else.
that was inter-office communications. This I-9 stuff is being blown totally out of proportion. Let me say this. The I-9 stuff, she actually sent 2 employees to San Antonio to be schooled on I-9 stuff, and they're working on I-9 stuff. There was never any whistleblower claim as a result of the I-9. She found something. When she's hired as HR director, you go in your office and you fix things that are broken. And that's what she was doing. There was no fraud there. There was no violation of federal law there. We're fixing this stuff. It's not fixed, by the way, today. But
So let me ask you this then. I'm just, I'm funny like that. I like to read the law every now and then and try to get you to, not lawyer around the law. But the law does say if she reported it to anybody, a public employment, to the agency head, who would be our agency head for Ms. Toledo?
her agency head would probably be Ken Dawson.
And who
or
else?
the parish president.
Okay. To the Board of Ethics.
She didn't report anything to the Board of Ethics.
But that's the second part. And the third part says, or any person or entity of competent authority or jurisdiction. Who would that include?
Say again, I'm sorry.
Or any person or entity of competent authority or jurisdiction. Who would that? Pretty much anybody that's over her for the parish, correct?
Yes, but
Okay.
she's never done any of that.
So what she
That is
said was
incorrect.
what she said was a lie earlier.
Let me say this, guys, as I said when I started, I've been in this case 2 months. Tonight is the first time I've heard whistleblower, retaliation, race, and gender. None of this. We had Mr. Pettit's here. We have the HR board. We had a full-blown hearing. None of this stuff was there. This is all, she's been terminated, and people, when desperate times, take desperate measures. And so now I'm here, I've been terminated. This is my last chance before I go to court. I've got a couple lawyers with me. I am a lawyer. And let me throw some stuff out. She has not made she's not made a whistleblower claim to the federal government. Have you? Have you turned us into the federal government? Because we sure didn't know that. Wanda Galera's working on the I-9s right now. Get them in order.
But that actually wasn't my question. My question was, did she report it to anybody that will be covered under Louisiana Revised Statute 421169?
I don't think reporting that your forms in your office need to be fixed is making you a whistleblower. I think reporting criminal conduct, unethical conduct.
That's not what the law says, though. The law
That
says
is
Louisiana law protects public employees who report information which they reasonably believe is a violation of any provision of law or other acts of impropriety.
Councilman, if you terminated for that reason, she's never been terminated for anything to do with I-9s.
Well, if you go off of what
reporting I-9s.
Councilman Sally just said, we're not really sure why she got terminated. We got said that she got terminated
Look,
based.
at the hearing, Council Beckley, we had evidence of 2 coaching forms and a disciplinary action form, which, let's be honest, the disciplinary action form where she wanted to demote an employee is really the catalyst for why we're here now.
Well, let me ask you, what is the coaching form itself?
The coaching form?
Yes, give me the definition of what a coaching form is. What's the coaching form?
I guess the purpose of a coaching form is to get somebody's conduct to come into line with where they should be, or to tell them what the culture of the organization is. But here's the problem there.
Okay, hold on. No, I want to try to, steer this where I want to be steered. I don't want you to just try to go somewhere else. So we have a coaching form. So don't we have a disciplinary action form as well? Or a form that when somebody gets wrote up?
Yes, we do.
So what's the difference between those 2 forms? Why was she not given the other form?
Oh, I have no idea.
Okay, so what exactly is the other form?
Which form?
We have a coaching form, correct?
We have a coaching form.
Then we have another form when
which
somebody's getting
which is
wrote
a
up.
disciplinary action form, which basically says
Does she have any of those? Did she have any of those disciplinary action forms?
Yeah, absolutely. In this case.
Which one is that? What is that for?
That was the one where she chose to try to demote an employee in her office who had taken family medical
Is that in
leave,
our packet?
and she tried to demote her the day she came back.
Is that in our packet? Was that
Yes,
given
it
to?
is.
With permission from the parish president.
That's actually going to be the second appeal that we're going to do tonight.
Okay, so we have one, and how many coaching forms do we have?
2.
So she got fired for basically one disciplinary action form?
No, she got fired for the sum total conduct of a year of history of work.
And, you know, as Councilman
Which
Saleh just said,
our
it's not,
personnel manual lets.
but it's not defined. I mean, I
It's
understand,
defined.
I understand it's an at-will employment, I understand all that, but she brings up a good point as far as the retaliatory action.
No, sir, I respectfully disagree. There has never been an allegation of retaliation in this case.
But you keep saying that, but tonight, and as long as she,
Tonight, we're-
but hold up, but as long as she reported it to anybody of competent jurisdiction, it's an allegation that's been made.
Report what?
Anything that the parish was doing wrong.
Anything they're doing wrong or anything that's illegal?
It says wrong. It doesn't say illegal. I mean,
So if she
do I
sees
need
a
to show you the
parish
statute?
employee run a red
No,
light,
let me
and
ask
she
you,
doesn't report that.
do I need to show you the statute? Well, actually, if you want to
No, I'm familiar with the statute.
Well, actually, that would be true because she was breaking the law. So if she sees a parish employee constantly running red lights in a parish truck, and we tell, or she tells the parish president or whoever else, and they refuse to fire that employee, and they fire her for keep bringing it up, that would be in violation of retaliatory statute because they're breaking the law or they're doing something that is seen as being wrong.
Here's how I see the whistleblower statute. If she
Well, we're going to see it
reports
in
an
your eyes. We're
I-9
just going to read the statute. I mean,
if she reports an I-9 violation and the administration finds out and they retaliate against her for doing that, then you have a valid whistleblower claim. She has not filed. I tell you, standing here right now, I guarantee you, she has not filed an I-9 violation claim with anybody.
is there any way that we can put the statute up on the screen so people can see what it actually says?
I'd like to see it.
Because this is,
Well, if you
Sir,
have, you
also-
can put them up, I guess John could come out here, but if you had a paper copy or something, you could do it on the projector at the podium.
Another issue that I wanted to bring forward is one of the
So I want to
things
ask you,
that
Ms.
Mr.
Wesley,
Satterley-
so the testimony phase is over, so if they ask you a question, you can answer, but if Mr. Turner has the floor at this point in time.
yeah, I would like to get that put on the screen so everybody can see it instead
Yeah.
of me just reading it and they having to figure out exactly
I don't,
what's
I'm not
being
sure
said.
how we do that.
You got that on your laptop?
It's on my iPad, yeah.
Yeah, can I put it over there on that projector?
You might be
For you?
able
I don't
to.
know if that's going to work.
It won't pick
Well,
up.
that's-
Oh, it'll work.
Can you do that?
There you go, it's on.
There we go.
And it's blurry on our screen.
Don't look that good.
You got focus, see if you can focus, yeah. Big John.
Bring in the mask.
No.
Cut off right there, say. You have to touch the screen.
Oh, did it touch the screen maybe? Because that maybe it's going dim.
Oh, there.
Thank you, John. Mr. Turner.
Yes. Now, I know we have a lot of conferring going on with the attorneys for the parish now, but I need Mr. Diaz or one of the many attorneys for the parish to show.
Ross Dooley, who represents us, just advised he's won a whistleblower case recently.
Well, I won a lot of cases myself, but I'm not bragging
And
about
so-
that today
but
either.
he
I just need
probably
this.
will.
I just need the answer on the statute.
I just don't think it applies. I think it has no application here.
But can we at least look at it then
Yeah,
and let
well,
everybody
sure.
look at it?
You want to come up, Ross?
I mean, all attorneys think they're right, whatever side they argue on. So let you know, come
We're not
on.
all attorneys, though.
Exactly. I understand that.
Mr. Chairman.
That's why we're trying
I'm
to put
gonna
it up. there.
apologize, I don't have a law degree, okay?
You're wrong.
Sometimes that's true of council people, too.
Yeah.
But, you know, I just kind of want the council to read what the whistleblower statute actually says and apply it to the facts that were just told by Ms. Wesley. And, man, if y'all feel it's wrong, if y'all feel that it doesn't apply, it doesn't apply. But I just want the accurate law to be presented to the council so they can make their own decision on it. I mean, because, you know, we
Okay,
all-
so where are you going, Mr. Turner? You want
Well, as
you have
far
a
as-
question here, or?
well, no, as far as she can report whatever she reports, it doesn't have to be an actual violation of the law.
So are you looking for an opinion from,
No,
the
I don't
two
need their opinion.
attorneys here,
I know
or-
what it says. But
Okay.
I want the rest of the council to be able to look at exactly what the law is saying, instead of us just going back and forth saying exactly what the statute is, without
Okay.
y'all being able to read the statute.
Oh, okay. So do you want to read it to us?
I mean, y'all gonna read it. I don't think I need to read it out loud.
Well, it's hard for me to see, but maybe y'all can see it.
Well, when I read it earlier, the Louisiana law protects public employees who report information which they reasonably believe is a violation of any provision of law or any acts of impropriety related to the scope of our duties of public employment. So it doesn't have to be a violation of the law, and if you go further, as long as she reports it to their agency head, the Louisiana Board of Ethics, or any person or entity of competent authority or jurisdiction. So long as she reported wrongdoing to almost anybody that's either on her level or above her, this brings this whistleblower statute into effect.
Okay,
Because
so-
because you take this into context with, we fired her because. Then that brings this into, in my opinion, this brings this into effect. Now, we may, now 9 times out of 10, y'all probably not gonna vote 2/3 to bring it back tonight, which, that's on y'all. But that still is gonna bring a great legal issue that's gonna be decided at court that can cost this parish a lot of money.
So we have, would either one of you guys like to comment on that, Ross or Mr. Diaz? Yes.
Thank you, Mr. Chair. Allegations are not proof. And this, as Mr. Diaz said, I was also at the HR board review hearing. None of this was brought up. It wasn't. And the burden is on her to establish it. She's here tonight making spurious allegations that are unfounded. And if she had that proof, other than what her statements are tonight, she should have brought it forward. At the end of the day, the level of proof that she's going to have to rise to prove such a claim is established by law, and that would be decided by a court of competent jurisdiction. But here, she's not done that, just merely throwing out what I believe to be spurious allegations, and that just simply does not rise to the level of proof that she would need to establish this.
Okay. Okay, Mr. Attorney, any further questions or comments?
For right now, I'm done.
For now, okay. So I got Mr. Lawler, another attorney.
Actually, I have a question.
Can I have my iPad back there so I can finish looking at more laws?
I have a question actually for Mr. Barrington.
I have the complaint here in my hand.
Okay, but I've got a question for Mr. Barrington first, because I want to make sure that I understand what us as a council, our role is, and what we're doing here tonight. Other than an illegal firing, whether it be for any reason that's illegal, we are acting as a check and a balance on the president's ability to fire at will. Is that a fair statement to look at it?
That's correct.
So if we wholly disagree with what the president did, or we want to exert increased supervisory powers over the employment of the parish, we can do that in this situation. It'd be a corollary to our ability to remove a department head by 2/3 vote. And we can do that without any reason.
I
Once
don't
again, that would
understand
be.
the question. You're free to return an employee. You're not free to change how the parish operates because the charter says.
No, I understand
Right,
that. But what I'm saying is we, as a parish council, have the ability to remove a department head by 2/3 vote.
Right.
And once again, that is an at-will thing. But tonight, we're not bound by whether or not we think Ms. Wesley did a good job, whether she did a bad job. We are looking at the parish president's decision, and we're deciding, really, it's whether we agree or not, and that is really our only role here. It's not whether or not Ms. Wesley did a good job or a bad job, it's do we want to overrule the president in this situation?
That's the question. Do you want to vote 2/3?
I disagree.
Okay, so now, all right, further questions from the council? All right, hearing none, then, oh, Mr. Savage.
Yeah, I just want to follow up to something that Travis said, and then Mr. Diaz.
No, she doesn't have the podium.
So
you can leave that, I'm sorry, Mr.
This
Savage.
question's
Hold on
to
just
Mr.
a
Diaz.
second. You can, if you have something for the council, you can leave it with Ms. McKee. As for Mr. Diaz, so Mr. Diaz, would you come to the mic?
Yeah.
Yes, sir.
For us to make our decision tonight, and that's all we all want to do is make the right decision. You said it was important that Ms. Wesley would have brought up the I-9 issue or any whistleblower issue at the HR review meeting prior to this, but she didn't. Is that right?
Well, it's important when you had a
I'm
trial
not
or a
asking you to
hearing to
justify,
bring
I'm
your
just-
evidence, bring your best evidence. You bring it at trial, you don't bring it at the
Okay,
appeal.
okay, that's fine.
Okay.
But the vote was 2-2, and that's without that I-9 information being brought forward. I'd have to wonder, would it change things more if it would have been brought forward as an allegation in her defense then? It was 2-2, was it not?
It was 2-2, but the way they do that, we do the hearing and then we leave. And we don't even know the decision till.
I understand, but so we're back to at will, period.
No, this case, this
But
is
I
all it's
think we
about.
are, because sometimes it seems like you're saying we are, and sometimes it seems like you're saying we're not.
This is number one, the
Because if
HR.
it becomes important to talk about I-9 ahead of tonight, or whether she did it to the Board of Ethics, I mean, that's an allegation not proven tonight. Maybe she did, maybe she didn't file a complaint. I don't know.
She didn't.
So I'm just supposed to believe that too?
Up until now, I've asked her, up until now, we've seen no evidence.
I
that
thought
she's-
Ms. Wesley testified tonight that she filed a complaint with the Board of Ethics. Is that not true?
That was.
Is it not true that she said that?
After she was terminated, she filed a
Right.
complaint.
And
with
this is
ethics.
after a 2-2 decision, but we still have to make a decision because it's part of the process.
Yes,
And-
sir.
And the 2-2 decision did not have any I-9 information presented at it, is what you're saying. And you're saying that would have been important to us making a decision tonight, that information would have been at a previous step. Well, maybe it would, maybe it wouldn't.
Well,
I don't
no,
know.
because then I
'Cause
would've- then I would've
still-
had a
well, Let me
chance.
finish.
Okay.
I still cannot figure out why she's been fired.
Oh, no, she's been fired because over the course of a year, she's not proved to be a satisfactory employee in the position of HR director.
With unspecified reasons why.
No, we have 4. We have 2 coaching forms and we have a disciplinary action form. And then we have just the general.
You named 3, you said 4?
I'm sorry, I said 4. Well, the 4th one is just general thing that is in the DAF about it's just not working out.
Okay.
It's just
Thank-
not working out.
Thank you for coming back to the mic.
My pleasure.
Okay.
Mr. Dawson has something.
Yeah, Mr. Dawson.
Let me just say this, because there seems to be some question, and I hear the whistleblower and I hear all of this, and it seems to be kind of insinuating that there were statements that were made possibly to me that I didn't take action in correcting. That's not true. Anything that was brought, and even there were some actions that was brought to me, I gave it to the attorney. Okay, he dealt with it and he answered the questions. The I-9s were brought to me. We've tried to figure out how we're going to deal with it with a limited staff. So I take issue of anybody stating that anything brought to me, that for some reason I'm going to suppress that and to say that this is something that I don't want you to move forward with.
Okay, thank you, Mr. Dawson. So now we're at this. Ms. Casso.
Yes, thank you very much, Mr. Chairman. I want to look at that whistleblower law one more time in writing up there, because there is one question.
It's gone.
There's a-
It was
Travis,
here,
can
it's
you get that
gone.
back up
What is
for
it,
me,
Travis?
please?
The whistleblower has been blown.
I get that. But I do want to look a little further down in that, because I think it would, I think what if indeed
Well,
I
O'Neill
saw
can
what
get it
I
up
thought
for
I
you.
saw, then I know what my position will be on the whistleblower
Terry
issue.
O'Neill has it here.
Well, if you'll put it back up, I think it would be helpful if everybody saw it.
There's no whistleblower issue here.
Well, so as what I saw, I think everybody stopped reading, and it says, this law, revised statute 42-1169, is enforced by the Louisiana Board of Ethics. A public employee who is wrongfully suspended, demoted, or dismissed due to the reporting of an act of wrongdoing shall be entitled to reinstatement. I'm not aware that any of this was brought up ahead of time, and so Toledo was fired because she brought any of this up. Am I right in reading that?
Ms. Castle, that's been my point since we
Okay.
started. is
I
that
just wanted to see that it was, okay.
No claim has been filed with any agency that there has been a wrongdoing in this parish. Now, with the Ethics Board, prior to termination. After termination, we have no idea what she's done.
Right, I understand.
Oh, no, we do. We filed several lawsuits. But the point is that prior to termination, prior to the HR Board hearing, there was no I-9 subject, there was no Ethics Board subject, there was no you violated this law or that law subject.
That is incorrect. I actually delivered additional documents, and that was going back to Mr. Sadler's question about whether you had all of the documents available to the HR board, and you do not have that right now. All you have is the parish's side.
Okay, so let's, do we have any other questions?
And
Yeah,
if you
Ms.
notice, the
Casso.
document that I gave you was
So we're
dated
gonna-
in March of this year.
Yes, that
Okay.
was dated March. She did file an ethics complaint, but the parish didn't know about it. And the ethics board has responded now, and they're not acting upon this complaint. They didn't find it was valid. So just to let you know that. Because
Okay.
we received your recent letter from the ethics board.
Did she get a right to sue letter? Did she get a right to sue letter?
No, she did not.
They don't do that.
No.
Okay, I'm just asking.
There
if
was
she
not
get
a
one.
there was not found to be a violation.
So there's no EEOC complaint pending?
Not that we know of.
Okay, Ms. Casso has some questions.
Thank you very much, Mr. Chairman. So just a couple of follow-ups, and I'll address my questions to Ms. Wesley's supervisor, Mr. Dawson. So and a statement of fact first, that in 2017, we did an efficiency study.
Yes, we did.
4 of the 11 recommendations related to that study, that came out of that study, were related to the HR department. Am I right?
That's correct.
So I want to know, do we have, one of the recommendations was that we have a performance management system put in place. Has this been done?
Not yet. In the process.
Thank you. One of the top priorities for me was that there be leadership and supervisory training in place across the parish. Have we had any scheduled trainings for supervisors across the parish?
There were some that were scheduled. We did go through and select a company that had all the training in-house, and we were in the process of moving forward. We're trying to implement that throughout the parish, but it was being scheduled.
Were there regular staff meetings held with the HR department?
It's my understanding, I know I attended a couple myself over on the West Bank, and it was my understanding that they were having, I guess on Thursdays, whatever day it was, till 10 o'clock or so staff meeting. I attended a couple of them, so I can definitely account to those two.
Let me see if I have anything else. Other folks asked questions that were, certainly I shared their concerns, and so I'm going to have to go through my notes here just to make sure I hadn't missed anything. I think I'm good. Thank you very much.
Okay. Any further questions from the council? Okay, hearing none. So if we can have a seat, Ms. Wesley and Mr. Diaz, thank you. So now the floor will be open for a motion, only a motion to overturn the parish president's decision.
Motion.
Got a motion by Councilman Turner, second by Councilman Joseph. Okay, any discussion on that? We will have it requires a 2/3 of members present to vote in favor of this to overturn the parish president's decision. So, Ms. McKee, would you open the machines, please? And this will require 8 votes of 2/3 in favor. So we have 5.
Wait. This is to.
Voting's still open. A vote in favor of this is to overturn the parish president's decision. A vote in favor is to overturn the parish president's decision. Okay? So please close the machines. That motion fails. 4 in favor, 7 against. Now we go to item number 2, which is to affirm or overturn the president's decision to reprimand Toledo Wesley. And we will start this process again. And Ms. Wesley, you will have 10 minutes.
Could I ask some questions prior to?
What?
Since this was his deciding factor, if this is overturned, then do you go back to the termination question? That's why I said it was backwards.
No, this is entirely separate a separate decision. You appealed each one of them separately. A decision has been made on item number 1. So if item number...
The appeal for the disciplinary action came before the actual termination because I got the...
Well, it didn't come that way on the agenda. So the agenda, on this agenda item, the decision to terminate was upheld. Now we're to affirm or overturn the decision to reprimand. So if this is overturned, then the letter of reprimand will be removed from your file.
But that was the basis for his termination. I kind of feel like that was it was done backwards, and 2,
Mr. Chairman.
it was unintentional.
Okay, so we'll lodge your feelings on that. Well, you got 10 minutes.
15?
Do you need 15 again?
I'm not quite sure. I thought I'd be able to get through everything the
Mr.
last
Chairman,
time.
you
I have
did
a lot
say
more to
you
tell
would
you.
give a 15 vice 20.
What? I'm trying to negotiate here. 15, that's good. Okay.
Okay. To understand why this document is so important, you have to understand its background and the reasons for disciplining this particular employee. I first gave a disciplinary document to that employee earlier in the year for benefits issues. Issues with our biometric event, educational requirements weren't scheduled properly, and they weren't communicated to all employees. So all employees didn't get the benefit of actually attending the event. Responses to inquiries. Leaders and employees were complaining about not receiving a response. The internal inbox would overflow with documents, causing missed opportunities. Timeliness, that person would often arrive at the office more than an hour and a half late. The second disciplinary or demotion document was given in August. Performance and ethical violations were discovered when I went into the office to pay bills and service employee requests. I and the assistant director communicated everything to the CAO, who in turn informed the parish president. Both leaders agreed with the demotion, with the parish president setting the person's new rate above and beyond that of the new role, which was out of alignment with the council-approved compensation plan. A PAF, a personnel action form, was then sent to the parish president the same day. Her role then changed into a lower role, but the pay hadn't changed because the parish president hadn't signed the document, and that's not uncommon. We followed up because he failed to sign the document. 4 weeks. This continued, where private conversations were held between the parish president, the actual employee, and the parish attorneys. So some of the primary issues that this person was being demoted for were untimely payment to vendors. One reported not having received payments for several months. Loss of enrollment documents, untimely processing of benefits, employees enrolled in benefits that they did not request, employees not enrolled in benefits that they did request, employees paying for benefits but not enrolled in said benefits, and the parish paying for employee benefits that were not being deducted from their checks, which is illegal payments according to the ethics board, and gifts to the employees, which is another violation of the ethics board. Our FMLA was not being monitored. Our insurance roster, which everything is done on paper, hadn't been updated. Our FMLA roster hadn't been updated. The office was unorganized with documents dating back years that hadn't been filed and had recently been needed in order to meet the needs of employees. Office decorum. The employee would often spend hours on social media using the parish's computers and her cell phone. Employee privacy. She used a backdoor program to email herself copies of private employee files containing their social security numbers and medical information. Once she returned from leave, it was found that she was rummaging through my office. This person still has their job. I did meet with Attorney Jeff Diaz along with the CAO and the Assistant Director, who agreed in his early assessment that she should be fired, but would research the matter in its entirety.
What did he say?
He also was also shocked to find out that the point of order, you're not, he was also shocked to find out that the
Wait, do
parish
you think
president
there's
had
a
not
violation
decided
here?
the
Because
PAF.
you can't just object that she's not saying something that's correct, but
Point of order.
You're not following your own rules.
Well, you have to understand the history of
okay,
it.
so we're gonna be patient. Thank you, Mr. Diaz.
He was also shocked to find out that the parish president had not signed the PAFs for weeks or even communicated his reasons why. In September, without consultation from nor notice to my department, we received a copy of a letter drafted to the employee from the parish president stating that the discipline would be upheld, but he would deny the recommendation for demotion, specifically stating, "You will be returned to your position." And we did as directed. This person still has their job. This is also the same person that I recently witnessed working at another organization during a work week, which is against the parish handbook. The document states that it's well established that only after the parish president acts on a PAF can an action be taken. That's false. Countless times we have received directives from the parish president prior to a PAF being initiated. Job changes, terminations, transfers are often moved forward with before a PAF could be initiated. There are often times in which the parish president derelicts his duty and does not sign documents for days up to months, in which time the action has already taken place. An example is an employee who was terminated and appealed their action at the HR board. Her PAF was submitted to the parish president the day she was terminated, and at the time that I was fired, her document still had not been signed. So to say that I'm insubordinate in my actions is absurd because all of this was communicated to the CAO and the parish president. Ironically, on the day of my separation, I received the disciplinary action at hand. At 8 a.m., I received the document. By the end of the day, all of my electronic access had been taken away. I had no access to emails nor to files on my computer. If you notice in your packets, I was fired on the 12th. But the PAF was not created until the 19th and signed by the parish until the 20th. So should I have received additional compensation until the 20th? Was I still an employee on the 20th? The parish does not have a policy on how PAF should be processed. The parish does not have standard practices on the manner in which PAFs are processed. The parish president changes the length of time and what should be included depending on the person. A PAF is simply the final record of an action that has been taken place. And of course, he's the president. He can change his actions at any time. But I was not insubordinate because I received direction from the CAO and he understood where I was going with everything. My assistant director was there with me, and they all agreed on the actions moving forward. I would like to reserve my time.
Reserve it for your 5-minute.
Yes, sir.
Okay, so the parish representative.
Good evening, ladies and gentlemen. This is the second appeal, and I know you always hear this out of me, and this is real simple, despite what we just heard. This appeal is whether Ms. Wesley should have received a written reprimand for insubordination. When this employee came back from FMLA leave, the same day she came back, Ms. Wesley, our acting HR director, gave her a demotion that was going to cost this lady $24,000 in salary, her office, her computer privileges, her exempt, non-exempt status, and other conditions and benefits of her office. Parish president took that under review, talked to parish council, Mr. Parrington, who referred it to me because of the FMLA issues. Can you act that quickly against an employee who's just coming back from FMLA leave? So we did some research and came up with an answer. But the problem is that while we're doing all this to protect this parish and to protect this lady that took FMLA leave, Miss Wesley didn't wait. She didn't wait for the parish president to sign the PAF. She took those actions. She took that lady's computer privileges away. She changed her office location. She changed her job title. She changed her exempt, non-exempt status. That's pretty big, guys. Parish president hadn't acted yet. Everybody knows until he acts, you don't do anything on the PAF. It's there. She says a final record. It is. Who's the final say-so? He is. Wait for him to act. Do not take an FMLA leave employee and impose your own will and discipline as the HR director on that employee. Don't change her office. Don't take away her computer privileges. Don't convert her status to non-exempt exempt. Don't change her title. Don't demean her any more than she already was. The day you gave her that demotion, the day she came back from FMLA leave. But Miss Wesley knows that. I had the transcript of the HR review board transcribed, the tape. HR review board member Stacy I tried the same thing and I got overruled, so I would ask that you overrule her. This is argument and this is latitude. And this is a transcript.
Would you, okay, well, make a copy for Ms. Wesley and her attorney
sure.
and send it to her? Or do you
absolutely.
have a copy there?
I'll give her mine tonight with all my orange on it. No, because it's her words. That's why it's damaging. In fact, I've heard her words tonight damaging her a lot. But here we go. Have you ever made changes to an employee's status prior to receiving a final decision from the parish president? That was from an HR board member. Miss Wesley, the parish president has. The member says, okay, so, but that's him. Have you ever, for any reason? Miss Wesley, I have not. Miss Wesley never. She knew that when you sent the PAF to the parish president, you waited on him to act. Yes, obviously she had an axe to grind with this employee, and she was determined to get away, and determined to demote her, determined to reduce her salary, but she had to wait for the parish president. That's why, and look, all she got out of that was a written reprimand, and that's what we're appealing right now. Or discussing. I'm not appealing. That's what we're discussing. A written reprimand for insubordination for acting on a PAF before the parish president acted. It's plain, it's simple, it's done, it's on the record. She knew better, she didn't do it, she was reprimanded, and that's all I can say about it.
Okay.
And I would ask that that decision, the written reprimand, stand as well.
Thank you, Mr. Diaz.
Thank you.
Okay, Ms. Wesley, you'll have some 5 minutes plus what you had left over. So.
Thank you. I'd like to say that, again, none of these actions happened without the approval of the parish president. Not only that, during the demotion meeting with the employee, the CAO was involved in it. He was getting his directives directly from the parish president. And like I've said before, which is incorrect, that Mr. Diaz said, is there have been actions taken prior to a PAF and on a common basis, such as the employee that was fired months ago. So should she still be receiving compensation if the PAF was never signed? What about me? 8 days later, my PAF was signed. If you're going to say that I was incorrect in that in moving forward, then I deserve 8 days of compensation because essentially I wasn't fired until the 20th. So these matters happen often, but they also change often depending on the employee. So that particular employee that he sat on, white employee, needed to be employed for insurance benefits reasons. And he kept her on. Okay? He kept her on. She needed to file for certain benefits, and he kept her on. He didn't sign that document, but she was fired for cause. So things like this happen often, and the fact that I had my CAO in there with my assistant director stating all these things were okay to happen. Let's think about the definition of insubordination. Insubordination is doing things that you were told not to do. Well, guess what? Everyone agreed that I should do it. So where's the insubordination? Thank you.
Okay, so now we'll open the floor up for questions from the council members. Mr. Joseph.
I'm gonna ask Mr. Dawson. Mr. Dawson, were you in those meetings to discuss this employee? And what was, from your point of view, what was the agreement or direction was given?
If this is dealing with the issue with the PAF, with that particular employee, there were discussions about the work and what was being done. At that particular time, there was agreement that we need to move forward. That information, there is not, the way that I work it and the way that's been working not only in this administration, but the past administration, there's no actions taken unless the president signs the PAF. It's always been my understanding and the way that it happens. Now, if something goes through the crack or happening in HR that may not, it may be the efficiency thing that we have, which is what we're trying to correct in HR, but the bottom line is the president, there's not a raise, there's not a demotion, there's not a decrease unless the president signs and says that he wants that happen. I don't sign it, he does. Now, when that discussion was had, we brought to President Matassa about the issues. He agreed that there were some things that needed to be done. It was my understanding that after a certain point when he got a little concerned about the FMLA issue, he brought in Mr. Perriton, they had a discussion about it, and so he decided not to sign the PAF because he was concerned. That's when I informed that to Ms. Wesley, that there was a discussion with the attorney, and they decided not to move forward with the signature of that PAF for that reason.
Okay.
And that was after.
Okay, Ms. Wesley, please.
My next question is then, were you aware of those meeting with the parish president, Mr. O'Neill, and the employee?
After it happened, yes. I was informed that they had a meeting and they discussed the issue after.
Okay, further Mr. Lawler.
Yeah, actually, I'm hoping to kind of short circuit this. I was going to move for a directed verdict after you originally spoke. I think the issue's moot at this point. You know, I mean, if we've already decided on one issue.
Eric, you might need to say what a directed verdict is.
Yeah.
Please.
We're going to follow this process.
Well, it's not a real directed verdict, but the point is.
It doesn't pertain to this.
Yeah, the issue
tonight.
is moot at this point. Even if we overturn that, it has no effect. If we overturn, I just don't see, am I correct, Mr. Barrington?
The decision's already been made on the termination.
Exactly. So this disciplinary issue is of no issue at this point. So there's no point in going forward on it.
It would result in the removal from her file, this disciplinary action. Do you have a question, Mr. Sadley?
Well, it's a question, comment, and for the record, and follow up to what something that Mr. Lawler just said. Mr. Diaz previously, on the previous item, stated that there were 4 things, and then he corrected to 3 when I quizzed him about that, for firing Ms. Wesley. Coaching, and the DA, the disciplinary action. So once again, for the record, if we would have heard the disciplinary action issue first, as Ms. Wesley requested, if it were, because now I agree with Mr. Lawler, he didn't say it this way, but it's probably moot. If it were overturned, however, we would have been down to 2 reasons, not 3, underlying her termination. I think, because I'm not sure why she was terminated, and that's why I cast the vote I did previously. Not on the IP9, the I-9 stuff or anything like that. But it would have been down to 2 lesser offenses, coaching and coaching, which everybody agrees is to try to make the employee better and not very serious like a DA. So, Mr. Chairman, I have to agree that we've messed up here procedurally and heard these issues, in my opinion, everybody can throw stones at me, in reverse order. The order of hearing these 2 items, in other words, may have affected, had we done it the other way, as Mr. Wesley requested, the first vote to terminate. So where are we now? I mean, I'm even confused. Why are we hearing this second issue?
So again, this could result
take
in
it out
the
of her
removal
file.
of that letter from her
But
file.
it will not erase the possibility that it may have affected the earlier vote. That's all I'm saying. Thank you for listening.
Okay. Mr. Kluat.
Mr. Chairman, if you could re-clear something up that you stated earlier, that there's 2 different items at the request of Ms. Wesley.
It was being heard as 2 different items. Now, this agenda was sent out previously, sent out to everyone. There were no comments on it until the time of the hearing. Any further questions? Okay, so now the floor is open for a motion to overturn the parish president's decision.
Motion.
Got a motion by Councilman Joseph.
Second.
A second by Councilman Travis Turner. Right, are there any discussion? I'm not sure if we can have discussion on this, but so we'll have to.
This is just to remove the.
This is to remove the letter from the file.
And we have done this before with Ricky Compton, right? When he just, similar situation.
I don't.
Well,
Cut a deal.
it was public. It was.
Yeah.
That was in the paper, so I just.
Yeah, like this.
Oh.
He was reinstated, and then he resigned.
Okay.
Different case.
Okay, so again, this will take 8 votes in favor, which will result in a decision of the parish president being overturned. So a vote in the yay would be to overturn the parish president's decision. Please open the voting machine.
One more clarification question. It doesn't rehire her, correct? It's just removing.
That's correct. Just removes that discipline letter from the file. Okay, please close the voting machines. And that motion fails. There was 4 yeas and 7 nays. All right, we're going to, item number 26 is to go into executive session.
Motion, Mr. Chairman.
Got a motion by Councilman Todd Lambert, second by Councilman Cagnalotti. Please open the voting machines. You voted for Albert?
Vote Randy and Doc.
Randy
Vote
Doc.
for them.
Got a motion to go into executive session, Doc.
Doc. Vote.
Doc,
Doctor.
Oh, yeah, sorry.
please close the voting machines. We'll be in executive session.
Me and you were late.
If I said no, do we have to go?
Okay.
Motion to reconvene.
Got a motion by Councilman Lawler, second by Councilman Todd Lambert to reconvene. Any objections? Back in session.
I'd like to make a motion that we accept the agreement to make the repairs to the road to our satisfaction. Failing to do so, we reserve the right to take action on the bond.
Second.
And you authorize us to do that if necessary.
And we authorize, yes, we authorize the administration to do so.
Got a motion by Councilman Lawler, second by Councilwoman Casso. Any discussion? Any opposition? Motion's adopted. Next item.
Motion to adjourn.
Got a motion by Councilman Cagnotti, second by Councilman Todd Lambert to adjourn. Any objections?
Cinnamon.